ಸಂಜೆ ಆಗುತ್ತೆ. ಬೇರೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಗೊತ್ತಿಲ್ಲ ಅದೇ ಕೊಟ್ಟಿದ್ದು ಓಕೆ ಚಿನ್ನದ ಮನಶಂಕರ ಪ್ರಸಾದ ಯಾವತ್ತಿಂದ ಸ್ಥಾಪನೆ ಇರೋದು? ನಿಮಗೆ ಯಾವ ತಿಂಗಳಿಂದ ಅವನು ಅಕ್ಟೋಬರಿಂದ ಅಕ್ಟೋಬರ್ ನವೆಂಬರ್ ಡಿಸೆಂಬರ್ ಜನವರಿ ಅಕ್ಟೋಬರ್ ನವೆಂಬರ್ 3 ತಿಂಗಳು ಕಳಿಸ್ತಾ ಅವರು ಪಾಪು ಇಸ್ತೀನಿ ಅದಿಲ್ಲ ಇದು ಕರ್ನಾಟಕ ಮಾಡಿಲ್ಲ ಬರಬೇಕು ಈಗೇನು ಒಂದು
ಇಲ್ಲಿರ್ತಾರೆ ಅವ್ರು ಇರ್ತಾರೆ ಅಲ್ಲಪ್ಪ ಕೇಳಕ್ಕೆ ಸುಳ್ಳು ಆಗ್ತದೆ ನಾನು
ನಿಮಗೆ ವೆಬ್ಸೈಟ್ ಹೋಗೋದಪ್ಪ ನಮಗೆ ಆ್ಯಪ್ ಎಸ್ ಎಸ್
Hello. Court officer.
ಸರ್ ಅದು ಎದ್ರದಾಗ ಬರ್ತಿತ್ತಲ್ಲ ವಿ.ಸಿ ಲಿಂಕ್ಸ್ ತಗ್ರಿ
PC ಕಾರ್ ಲಿಸ್ಟ್ ಅಂತ ನೋಡಿ ಸರ್.
ಎಲ್ಲಿ ಸರ್ ಅದು 3 ಲೈನ್ಸ್ ಅದಾವಲ್ಲ ಅಲ್ಲಿ ಇದು ಕ್ಲಿಕ್
ಇಲ್ಲ ಕಾರ್ ಲಿಸ್ಟ್ ಓಪನ್ ಮಾಡಿ ಸರ್.
ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್
ಕಲಬುರಗಿ ಬಂದು ಎಷ್ಟು ಅಷ್ಟು ಬಂದಿತ್ತು ಸರ್.
ಪಾಸ್ವರ್ಡ್ ನೋಡ್ಬೇಕು ಸರ್, ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋದು.
Bangalore court officer. Sir. ಕಲಬುರಗಿಯಿಂದ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮಾತಾಡ್ತಾ ಇದೀವಿ ಸರ್. ಬಂದಿಲ್ಲ ಬಂದ್ರೆ ವಾಯ್ಸ್ ಕೇಳಿಸ್ಕೊಡಿ.
Yeah, 2:30 ಬೇರೆ ಬೇರೆ ಇದೆ. ಜನ ಆಗೋಯ್ತು 27 ಒಂದು ಎಲ್ಲ ಹೌದು. 4 ಇಲ್ಲ ಸರ್, ಮಧ್ಯಾಹ್ನ 2:30 ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಇದೆ. ಅದೇನಾದ್ರೂ ಕಂಟಿನ್ಯೂ ಆಯ್ತು ಅಂದ್ರೆ ಯಾವ್ದು ಆಗಲ್ಲ. ಯಾಕೆ ಸರ್? ಹಾ, ಅವ್ರಿಗೇನೆ ವೇಟಿಂಗ್ ಬರಲ್ವ? ಅದೇ ಯಾರೋ ಹೇಳೋದು. ಏನಾಗಿದೆ ಸರ್? ಮತ್ತೆ ಅವ್ರಿಗೋಸ್ಕರ ಇಲ್ಲಿ ವೇಟ್ ಮಾಡಿ ಎಲ್ಲಾನು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ತಿದ್ದೀವಿ. ಈಗ ಮಧ್ಯಾಹ್ನ ಇದ್ದಿದ್ದೆ ಅವರು 52. ಇಲ್ಲ ಸರ್, ಇದೆ ಅಲ್ಲ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಅದೇನ್ ಲೆಕ್ಕಕ್ಕೆ 2 ನಿಮಿಷ 70 ವೇಟ್ ಮಾಡಿ. ಬಟ್ RS ತಗೊಳಲ್ಲ ಸರ್. ಯಾವತ್ತು ಫ್ರೈಡೆ ಅದ್ಯಾರೋ ಡೇಟ್ ಕೊಟ್ಟಿರೋದು ಬಂದಿದೆ ಅಷ್ಟೇ. ಫ್ರೈಡೆಗೆ ಹಾಕ್ಬಿಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಫ್ರೈಡೆ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆಗೆ ಆಲ್ರೆಡಿ ಫಿಲ್ ಅಪ್ ಆಗೋದು. 13, 26, 27.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ನೀವು ಈಗಲೇ ಕೇಳ್ಕೊಂಡು ಹೊಟ್ಬಿಡಿ. 23 ಇಲ್ಲ ಸರ್, 23, 30 ಎಲ್ಲ ಫಿಲ್ ಅಪ್ ಆಗೋದು. ನಾವು 2 ವಾರದಿಂದ ಕೊಡ್ತಾ ಇದೀವಿ.
ರಾಹುಲ್ ಇವು ಒಂದೊಂದೇ ಕಾಪಿ ಇನ್ನೊಂದು
ಇಲ್ಲ, ಏನು ಕೊಡ್ತಾ ಇಲ್ಲ ನಾನು, ಏನೋ ಇನ್ಫಾರ್ಮೇಶನ್ ಹೇಳಿದೆ. ಫಸ್ಟ್ ವೀಕ್ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ವಿ, ಅವತ್ತು ವೇಟಿಂಗ್ ನಿಮ್ಗೆ ಬಂದ್ರೆ. ಅದಕ್ಕೆ ನಾವು ಬೋರ್ಡ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡು 13, 20, 27 ತಗೊಳ್ಳಿ ಅಂತ ಸಜೆಷನ್. ಯಾವ್ದು ಕೇಳಿದ್ರು ಕೊಡ್ತಾರೆ, ಅದಕ್ಕೆ. ಬಟ್ ವೇಟ್ ಮಾಡ್ಬೇಕು. 16 ಹೇಳಿದ್ದಾರೆ. ಬಟ್ 2:30 ಬೇರೆ ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಇದೆ, ಆಲ್ರೆಡಿ ಲಿಸ್ಟ್ ಆಗಿರೋ. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ಅನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ, ಬೇರೆ ಬೆಂಚ್ ಜೊತೆ 2:30ಗೆ ಬೇರೆ ಸೀನಿಯರ್ ಬರ್ತಾರೆ. ನೋಡೋಣ. ಕೇಳ್ಬಿಡಿ ಸರ್. ಸೋಮವಾರ
ಹಾಗೆ ತಗೊಂಡು
ಸೋಮವಾರದ ಲಿಸ್ಟ್ ಮಾಡಿದಾನಂತೆ, ಆದ್ರೆ ಸೇರ್ಸಿಲ್ಲ ಫೈಲ್ ಒಳಗೆ, ಹಾಗೆ
ಇಲ್ಲ,
ಕಳ್ಸ್ಬಿಡಿ.
ಬೆಂಗಳೂರು ಅಲ್ಲ, ಇವು ಕಲಬುರ್ಗಿ ಮಾತ್ರ ರಿಸರ್ವ್. ಬರೆಯೋದಿಲ್ಲ, ಫೈನಲ್ ಅಲ್ಲಿದೆ. ಬಿ ಎ ಮೇಲೆ ಹಾಕಿ ಬಿ ಎ ರಿಸರ್ವ್ ಇದೆ, ಮೇನ್ ಹಾಕ್ತಿಲ್ಲ ರಿಸರ್ವ್ ಆಗಿದೆ, ಅದು ಡಿಸ್ಪ್ಲೇ. ನಿನಗೆ ಅಕೌಂಟ್ಸ್ ಅವರು ಫೋನ್ ಮಾಡಿದ್ರೆ ಈಗ ಒಂದು ತಾಲೂಕ್ ಕಳಿಸ್ಯಾರ. ನೀನ್ ಬಂದ್ಮೇಲಾದ್ರೂ ನೀನು ಕ್ಲೀನ್ ಮಾಡ್ಬೇಕು. ನೀನ್ ಯಾವಾಗ ಬರ್ತೀಯ ಅವಾಗ ಕ್ಲೀನ್ ಮಾಡ್ಬೇಕು.
ಹೌದಾ? ಸರ್ 74 ಏನಾಯ್ತು ನೋಡಿ?
ಯಾವ ಲಿಸ್ಟ್? ಇವತ್ತಿನ
ಮಂಡೆ. ನೀವು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ಡೇಟ್ ಆಗಿದೆ. ಹಾಂ, ಅದು ಸಿಗ್ತಿಲ್ಲ. ಅಲ್ಲಿಗೆ
ಮಂಡೆ 74 92
ಹಾಫ್ ಇಲ್ಲ, ಕಾಂಟ್ಯಾಕ್ಟ್ ಅಲ್ಲ.
ಕನೆಕ್ಟೆಡ್ ಇದೇನ್ರಿ ಕನೆಕ್ಟೆಡ್ ಅಂತ ಒಂದ್ಸಲ ಅದೇ ಫೈಲ್
ಇದೆ ಸರ್ ಕಾಂಟ್ಯಾಕ್ಟ್.
ಮತ್ತೆ ಕನೆಕ್ಟೆಡ್ ಅಂತ ಹಂಗೆ ತಾನೇ ಹೇಳ್ಕೊಟ್ಟಿದ್ದ ಸೇರ್ಸ್ಕೊಳ್ಳಿ. ಎಷ್ಟು ನಂಬರ್ ಹೇಳಿ ಶ್ರೀ, ನಂಬರ್ ಹೇಳಿ, ಕೇಸ್ ನಂಬರ್
20042.
ಒಂದೇ 74 ಅಷ್ಟೇ. ಆಮೇಲೆ
ಇನ್ನೊಂದು
2086 ಸ್ಟೇಜ್ ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿತ್ತು ನೋಡಿ? ಯಾವ ಇಯರ್? 25.
ನೀವು ಬಿಡ್ತೀರಿ ಸರ್?
ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಸ್ಟೇಜ್ ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿತ್ತು? ಅಲ್ಲ, ಪುಟಪ್ ಪೆಂಡಿಂಗ್ ನೋಡು.
ಒಂದು ಫೈಲ್
ಅದರಲ್ಲಿ ಬ್ಯಾಚ್ ಕಳಿಸ್ತಾರೆ, ಎಲ್ಲ ಸಪ್ರೇಟ್ ಮಾಡಿ ಡಿಲಿಂಕ್ ಆಗಿದೆ. ಡಿಲಿಂಕ್ ಒಂದು 5 ಮ್ಯಾಚ್ ಒಂದು ಇದು ಮಾಡೋದು, ಒಂದು ಬ್ಯಾಚ್ ಸಿಂಗಲ್ ಒಂದು, ಮತ್ತೆ ಮೂರು ಒಂದು ಹೇಳಿದ್ರಲ್ಲ, ಮೂರು ಎಲ್ಲ ಚೆಕ್ ಮಾಡಿ ಎಲ್ಲ ಫೈಲ್ಸ್ ಸಪ್ರೇಟ್ ಒಂದೇ ಇದಕ್ಕೆ ಕಳಿಸಿದ್ದೆ.
ತರ್ಸಿಲ್ಲ ಕೊಟ್ಟಿದ್ದು, ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ
ಹಂಗೆ ಕಳಿಸೋದು.
ಮೇನ್ ಮ್ಯಾಚ್ ಒಂದು ಬರ್ತಿದ್ರೆ ಇಷ್ಟೇ.
ಮಂಡೆ
20560
ಸರಿ ಐತೆ ಈಗ. ಸರಿ ಆಯ್ತಾ?
ನಾವು ಕರಿಬೇಕು.
ಈಗ ನಾಗರಾಜಪ್ಪ ಅವ್ರದ್ದು ಸಿಗ್ತಾ ಯಾವ್ದಾದ್ರು ಕಾಂಟ್ಯಾಕ್ಟ್? ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಸರ್, 230 ಅಂತ ಬೇರೆ ಬೇರೆ ಇದೆ. 5 ನಿಮಿಷ ಏನೂ ಇಲ್ಲ ಸರ್, ಜಾಸ್ತಿ ಮಾಡಿ. ಇದು ನಾಗರಾಜಪ್ಪ ಅವ್ರು ಸಿಗ್ತಾ ಶ್ರೀಧರ್?
ಇಲ್ಲ
ಯಾವ್ದಕ್ಕೆ ಅಪ್ಪ ಇವಾಗ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೊಡೋದು?
ಇದ್ರೆ ಬರೋರು
ಈಗ ಅವ್ರು ಆನಂದ್ ಬರ್ತಾರಂತ ಮತ್ತೆ ಇವಾಗ ನಾವು ಅರ್ಜೆಂಟ್ ಮಾಡೋದು.
ನೀವು ಬರ್ದಿದ್ರಿ ಸರ್? ಮೇನ್ ಫೈಲ್ ಏನ್ ಹೇಳಿದ್ರು ನಮ್ದು?
ಅದು ಇವಾಗ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆ.
ಹೌದಾ?
4 ಒಂದ್ ಮಾಡ್ಬೇಕು, 3 ಒಂದ್ ಮಾಡ್ಬೇಕು, 1 ಒಂದ್ ಮಾಡ್ಬೇಕು. 5ರಲ್ಲಿ ಇದು ಅಂತ
ಈ ಸಿಂಗಲ್ ಬರೆಯೋದೀಗ
ಇಲ್ಲ 5ಕ್ಕೆ ಸೇರಿಸ್ಬೇಕು. ಒಟ್ಟು 7-8 ಫೈಲ್
ಮೇನ್ ಫೈಲ್ ನಂಬರ್ ಏನು ಸರ್?
ಯಾವ್ದ್ರ ಜೊತೆ ಸೇರಿಸ್ಬೇಕು ಆ ನಂಬರ್ ಕೊಡ್ತಾರೆ.
ನಾವು ಕಳ್ಸಿದ್ದು
My last leave, my lord. Serial number 73, RSA. Is a date given matter. Today it has come before your lordship.
Yes,
In normal course, I was told the matter will be taken up on Friday. Any Friday, my lord, which is convenient, my lord, will be taken.
73.
73, my lord.
73 will post on Friday.
Friday, my lord.
Yes, RSA will post it on Friday.
Any Friday, my lord.
Yes.
Any short period.
6th.
Great.
6th.
74 also RSA.
74. Yes, 6th.
My lord, serial number.
Serial number?
Hello, madam.
Serial number 77. Counsel for the
70.
appellant, madam.
Hmm.
6 a week of time.
When do you want? Any Saturday? So
2 weeks ಕೊಟ್ಟಿದ್ದೀವಿ.
2 weeks, ಅದೇ ಅಂದ್ರೆ 6th ಕೊಡಿ, 6th Friday.
Late, next date, no.
Next 30th.
Okay.
30th Friday. 2 weeks under 30th.
Acha.
64.
64.
Next week. A file objection.
64. You are appearing for?
Respondent, my lord.
I have informed other side.
No.
Inform ಮಾಡ್ಬರ್ರಿ. ನಾವು ಅರ್ಜೆಂಟ್ ಇದ್
I'll inform.
ಫಸ್ಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಆಮೇಲೆ ಕೇಳಿ ಅಷ್ಟೇ.
Serial number
ಮಾಡ್ಕೊ
36.
ಬಂದ್ರೆ ಆಯ್ತಪ್ಪ. Yes, you inform
Serial-
and ask. Yes.
Serial number 36 pass over ಆಗಿದೆ. 2 minutes ನಮ್ಮಲ್ಲಿ ಅನ್ಫಿಂಡ್ ಇದ್ದಾರೆ. ಎರಡು ಕಾರ್ಪೊರೇಷನ್ ರೆಗ್ಯುಲರೈಸೇಷನ್.
Pass over.
ಪಾಸ್ ಓವರ್.
Ready? Filed an objection.
ಎಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಹಾಕಿಲ್ಲ, ಹಂಗೆ ಓರಲ್ ಆಗಿ ಹೇಳ್ತೀನಿ.
Yes, pass over will take
Please,
that
please.
231 matter the ಮುಗಿಸ್ಕೊಂಡು
Please.
ಬರ್ತೀವಿ. ಗುಲ್ಬರ್ಗ ಬೈದಿರ್ಬೇಕು. ಕೇಳಲಿಲ್ವಾ ನೀವು?
ಹೇಳ್ರಿ ಮೇಡಮ್.
ಕನೆಕ್ಟ್ ಆಗಿಲ್ವಾ? ಏನ್ ಬಂದಿದ್ದಾರೆ? ಅಲ್ಲ ಇಲ್ಲಿ ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ, ಅಲ್ಲಿ ಕೇಳ್ಬೇಕಿತ್ತು. ಬಂದಿಲ್ಲ.
ಎಲ್ಲಿಲ್ಲ
ಸರ್ ಬರ್ತಿದ್ದಾರೆ ಸರ್.
ಎಸ್ ಬರ್ತಾ ಇದಾರ
ಬಂದ್ರು.
ಅಲ್ಲಿ ಗುಲ್ಬರ್ಗ ಸರಿ ಬಂದಿದ್ದಾರೆ ಗುಲ್ಬರ್ಗ.
Kalburgi bench matter, pronouncement of orders on IA, serial number 1, Sudarshan M for appellant, connected matter, Sarana Bashveshwara Mamadapur, serial number 1.
Yes.
145/2025. IA 1 of 2025 is dismissed. Criminal appeal 150/2025. IA 1 is dismissed.
Please, my lords.
Serial number 2, Mahantesh Patil for appellant, connected matter.
IA 2 of 2025 is allowed. the order of sentence dated 26/2025 of the learned third additional district and session judge Raichur, sitting at Sindanuru, veterinary at Lingasuru in SC 99/2021 is hereby suspended, and the appellants accused number 1 and 2 are enlarged on bail, subject to conditions.
Serial number 3, Ashok Mulage for appellant, SPP.
IA2 of 2025 is allowed. The order of sentence dated 26/2025 of learned third edition district and session judge Raichur, sitting at Sindanuru in SC 99/2021 is hereby suspended, and the appellants, the accused number 3, 4 and 6 are enlarged on bail, subject to conditions. Connected ಅಲ್ಲಿ.
ಇದು ಇನ್ನೊಂದು ಇರ್ಬೇಕು ನೋಡಿ 3.
Criminal appeal 200,355. IA1 of 2025 is allowed. The order of sentence dated 31/10/2025 of the second edition of district and session judge and special judge Kalaburgi in special case number 81/2022 is hereby suspended, and the appellant accused number 4 shall be enlarged on bail, subject to conditions.
Yes, brother. Thank you.
Thank you. Advance happy Makara Sankranti, my lord.
Thank you. Thank you. Same to you. Yes.
Thank you. Same to
Yes.
Principal bench matter, 230 matter, serial number 82, Samir Sharma for petitioner, Krutika Raghavan.
Yes.
My lord, I'm appearing for the respondent. We are led by senior counsel Mr. D.R. Ravishankar, who had a fall and is currently hospitalized, my lord. The matter, he's hospitalized.
Yes, yes.
It may be taken up next week, my lord, on 22nd.
At the request of counsel for the respondent, leave this matter next week. Please. Yes.
Great.
The undertaken given is extended till next date.
Please.
Yenagidri, what has happened?
He
My
had
lord,
a
we
chest
only.
congestion, my lord. For last 2 days, he was not well. My lord, before the Kotal number 11, while he was arguing, my lord, he had a chest cramp. He was taken to the dispensary and now he is taken to Apollo, my lord. But ECG and everything seems normal.
He's in hospital.
Yes.
Yes.
Or home hospital.
No, my lord, hospital.
Is
He's in the
everything.
hospital.
But his vitals are, parameters are all fine.
Yes.
Great.
Could it be at 2:30 on that day?
Let us see.
Very well.
Let him recover. Yes.
Very well.
Yes.
Great.
Fast over, fast over.
First over matter, serial number 14, Akshata Shetty K for petitioner, government advocate, serial number 40.
Yes. Your complaint office objection.
It is compliant. The government has been directed to name the council ಯಾರು ಅಂತ ಹೇಳ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರು.
ಯಾವ್ದಕ್ಕೆ? ಇದಕ್ಕೆ ಅಲ್ವಾ? That
Deduction of PF.
Accountant general ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್? ಅಲ್ಲ ನೀವು ಎಲ್ಲಿ ನಿಮ್ಮ ಕಲೀಗ್? She said somebody is there, I will verify. ನೋ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಿಮ್ಮ ಹೆಸರಲ್ಲೇ ಬರುತ್ತೆ, ಅವ್ರಿಗೆ ಆಮೇಲೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಅವ್ರು ಆಮೇಲೆ ಮತ್ತೆ ಟೈಮ್ ತಗೊಂಡು ಇಟ್ಸ್ ಆಲ್ ಪೆಂಡಿಂಗ್. Therefore I have passed over in that morning. Yes, pass over, let us. The moment she came, just mention, Mr.
Serial number 16, V. Keshavamurthy for petitioner, government advocate.
In this case, I appear for the petitioner, my lord.
Why it is passed over?
Yeah, the maintenance between the husband and the wife was settled before the civil court, my lord. Thereafter, they filed one application for that retirement benefit. That retirement benefit we have given endorsement that there is a case, criminal case pending between the husband and the wife, so it can't be given.
Yes, Mr.
My lord, respond number 3 is the husband of this petitioner. He has not paid the maintenance amount. Therefore, the petitioner has paid a petition OS for the civil court, wherein the parties have entered into compromise. In terms of the compromise petition is page number 64.
Yes.
In terms of the compromise, the defendant, that is the respondent number 3 herein, has agreed to sum of rupees 14,28,000 to be released in the name of this petitioner.
Go and execute that. Why do you file in a writ? Huh?
I have given this copy to the Commissioner of Police. He has given an endorsement annexure A.
No, execution petition is also dismissed. Why?
The execution not dismissed.
Pending. Then you go and execute there. Why do you want that writ here?
Court order now implement ಮಾಡಿಲ್ಲ ಅಂತ ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದೆ ಅದಕ್ಕೆ ನಾನು ಹಾಕೊಂಡಿದ್ದೀನಿ.
ಅದೇ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಇರೋದು. ಸಿವಿಲ್ ಕೋರ್ಟ್ order has to be implemented in execution, not under 226.
Despite that,
then I tell me withdrawing this petition.
Yes, withdraw with the liberty to pursue your execution. Yes,
please.
Learned counsel for the petitioner appearing through VC has submitted that. May be permitted to withdraw this writ petition with liberty to prosecute this execution petition in execution number 288 of 2025 pending before 4th Additional Family Court at Bangalore. To that effect, he will file in a memo in the registry. Submission is taken on record. The above writ petition is dismissed as withdrawn. Government advocate has approved. Yes.
Seal number 36, Somashekara RP per petitioner, BL Sanjeev.
But in this case, my lord, as per annexure K, my lord, the petitioner was directed to reinstate, directed to continue the services. So annexure K, ink page number 94, my lord. Earlier petitioner approached the same court, petitioner number 2. Flagship carried to page number 95, my lord. Next page. They may permitted to read that.
Yes.
The petitioners had filed writ petitions in WP so also, and they came to be disposed of when earlier when order dated 21/7/82, holding that the petitioners had not been in service as on 25/7/83. It is now brought to my notice by the learned counsel for the petitioners, who has filed this review petition, that the basis upon which this court disposed of the matter was that the petitioners were not in service as on 25/7/1983, but in fact the petitioners were in service even on 25/7/1983 as per annexure E, and that memo was not produced earlier. In the circumstances, the order made on 21/7/92 is reviewed and WP so are restored. Thereafter, next part. The contention of the petitioners that they are being employed by the respondent corporation on daily wages basis, and their services may be regular on the basis of the so and so manner. Thereafter, Melada, the order came to be issued as per annexure A, Melada. Annexure A, ink page number 13, Melada. Bengaluru ಮಹಾನಗರ ಪಾಲಿಕೆಯಲ್ಲಿ 25/7/83ರಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಮತ್ತು ತದನಂತರ ತೆಗೆದುಹಾಕಿದ ದಿನಗೂಲಿ ನೌಕರರು ದಿನಾಂಕ 3/1/86 ದಿನಗೂಲಿ ಹಾಜರಾದ ಕೆಲಸಕ್ಕೆ ಹಾಜರಿಸಿದ ಸಹ ಆದೇಶವನ್ನು ಪಾಲಿಸಲು ಪ್ರಶ್ನಿಸಿ ಆಯುಕ್ತರ ವಿರುದ್ಧ ಸೊ ನ್ಯಾಯಾಲಯದ ನಿಂದನೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಹಾಗೂ ಸರ್ಕಾರಿ ನಾವು ಮೆಲಾಡ್ sought for regularization and for other benefits. Now the endorsement came to be issued. Earlier I approached the Assam court. The Assam court directed the respondent to dispose of the representation in accordance with the
what is that endorsement now?
Annexure J, Melad, ink page number 92, Melad.
Yes.
B.R. ವೇಣುಗೋಪಾಲ್ ಪ್ರಥಮ ದರ್ಜೆ ಸಹಾಯಕ ಆದ ಉಲ್ಲೇಖ ರೀತಿಯ ಮನವಿಯನ್ನು ದಿನಾಂಕ 6/7/90 ಮುಂಬಡ್ತಿ ಹಾಗೂ ಸೇವಾ ಸೌಲಭ್ಯ ನೀಡಲು ಕೋರಿದ್ದು ಪ್ರಸ್ತಾವಿಕ ಉಲ್ಲೇಖ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕೆಳಕಂಡಿದೆ. Having take note of the contention in the representation, the respondent BBMP is directed to consider the representation in accordance with law. It is made clear that the Assam court has not expressed any opinion on this case. Considering the representation be made within 8 weeks from the date of ಅದರಂತೆ ಉಲ್ಲೇಖ ರೀತಿಯ ಕಾನೂನು ಕೋಶದ ಮುಖ್ಯಸ್ಥರವರ ಅಭಿಪ್ರಾಯ ಕೋರಲಾಗಿ ಶ್ರೀ ಆರ್ ವೇಣುಗೋಪಾಲ್ ಪಾಲಿಕೆಯ ಕಾಮಗಾರಿ ವಿಭಾಗದಲ್ಲಿ ದಿನಗೂಲಿ ಆಧಾರದ ಮೇಲೆ ದಿನಾಂಕ 25/7/83 ಸೇವೆ ಸದರಿಯನ್ನು ತದನಂತರ ಕೆಲಸಕ್ಕೆ ಬಿಡುಗಡೆಗೊಳಿಸಲಾಗಿದೆ. ಸದರಿ ದಿನಾಂಕ 25/23/12/80 ಕೆಲಸಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಕೆಲಸದ ಇರುವುದರಿಂದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಿವಿಲ್ ಅರ್ಜಿ
17/1/2060 ದ್ವಿತೀಯ ದರ್ಜೆ ಗುಮಾಸ್ತರ ಹುದ್ದೆಯಲ್ಲಿ ಕಾಯಮಗೊಳಿಸಿ ಕ್ರಮಬದ್ಧಗೊಳಿಸಲಾಗಿದೆ.
ಈಗೇನಾಗಿದೆ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ 8/3/18/96 ದಿನಾಂಕ 6/2/95 ಪಾಲಿಕೆಯ ಸೇವೆಗೆ ದಿನಗೂಲಿ ನೌಕರ ತೆಗೆದುಕೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ದಿನಗೂಲಿ ನೌಕರ 10 ವರ್ಷಗಳ ಸೇವೆಯನ್ನು 5/2/2000 ಪೂರ್ಣಗೊಳಿಸಿ ದಿನಾಂಕ 17/1/2006 ದ್ವಿತೀಯ ಗುಮಾಸ್ತು ಕಾಯಂಗೊಳಿಸಿ ಕ್ರಮ. ತಾವು ತಿಳಿಸುವಂತೆ ಪಾಲಿಕೆಯಲ್ಲಿ ದಿನಗೂಲಿ ನೌಕರ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ನೌಕರ 10 ವರ್ಷ ಪೂರ್ಣಗೊಂಡ ನಂತರ ರಿಟ್ ಅರ್ಜಿ 8/8/71 ಹಾಗೂ ಇತರೆ ಪ್ರಕರಣದಲ್ಲಿ ಸಕ್ರಮಗಳು. ಆದರೆ ನೀವು ದಿನಗೂಲಿ ನೌಕರರಾಗಿ 10 ವರ್ಷಗಳ ಪೂರ್ವದಲ್ಲಿ ಕೆಲಸದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿ ತದನಂತರ 6/7/90 ಮರು ನೇಮಕಗೊಳಿಸಿ ದಿನಾಂಕ 6/2 ಅನ್ವಯವಾಗುವಂತೆ ಕ್ರಮಬದ್ಧಗೊಂಡ ದಿನಾಂಕದ ಮುಂಬಡ್ತಿ ಹಾಗೂ ಸೇವಾ ಸೌಲಭ್ಯ ನೀಡಲಾಗುತ್ತದೆ. ತಮ್ಮನ್ನು ಪಾಲಿಕೆ ಸೇವೆ ಬಿಡುಗಡೆಗೊಳಿಸದೇ ಇದ್ದಲ್ಲಿ ಇತರರಿಗೆ ಪರಿಗಣಿಸಿ ಆದ್ದರಿಂದ ನಿಮ್ಮನ್ನು ಬಿಡುಗಡೆಗೊಳಿಸಿ ನೇಮಕಾತಿಗೊಳಿಸುವುದು ಮರು ನೇಮಕಾತಿ ಹೊಂದಿದ ದಿನಾಂಕದಿಂದ ದಿನವರಿಗೆ ನೌಕರರೆಂದು ಪರಿಗಣನೆ 10 ವರ್ಷ ಪೂರ್ಣಗೊಂಡ ನಂತರ ಕಾಯಂ ಪರಿಗಣಿಸುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಆದ ಕಾರಣ ತಾವು ದ್ವಿತೀಯ ದರ್ಜೆ ಹುದ್ದೆಯಲ್ಲಿ 6/2/82 ಕ್ರಮಬದ್ಧಗೊಳಿಸಿ ಸದರಿ ದಿನಾಂಕದಿಂದ ಅನ್ವಯ ಸೇವಾ ಸೌಲಭ್ಯ ಹಾಗೂ ಮುಂಬಡ್ತಿಯ ಅರ್ಹತೆಯನ್ನು ಹೊಂದಿರುವುದರಿಂದ ನೌಕರರು ಕೋರಿರುವ 6/2/90 ಅನ್ವಯ ಮುಂಬಡ್ತಿ ಹಾಗೂ ಸೌಲಭ್ಯ ನೀಡಲು ಬರುವುದನ್ನು ತಿಳಿಸಲಾಗಿದೆ.
No, you have been regularized. But you are saying that from 1995.
Given other benefits, considering the fact that I have been in service since from 1983. Though the Assam court has allowed the writ petition, since they have not taken any instruction, I have approached the Assam court on contempt matter. They have issued an order. Therefore, you have been appointed and said that therefore benefits cannot be.
Yes, Mr.
Lord, we'll have to reconsider the representation in lieu of the annexure K, which is 79 of 1993.
Yes, there that
That
wrongly
they
it
have
has
said,
been held.
that
Then
they
it
have
has
said
been-
that all benefits, my lord. In lieu of this, my lord, we'll have to reconsider.
Yes, this writ petition, petitioner called in question the endorsement dated 15/7/2023 issued by respondent number
Respondent number
2, my lord.
2, my lord.
issued by respondent number 2 with annexure J, where petitioner request for regularizing his service from 6/2/1995 is rejected. Case of the petitioner that was appointed.
Lord, may I just.
Yes.
Thank you.
In a corporation as a daily wages employee in 25/7/1983. Thereafter, he was removed from the service as per that order dated 23/12/1985. Hence, he has approached this court by filing a writ petition in 79/1993.
In page number 94, my lord. 95 operative portion.
Yes, this court by order dated 18th March 1993 has passed following order. Order portion extract money. Okay. Thereafter, petitioner has been taken back to the service
Annexure A, my lord.
by annexure A from 6/2/2005.
95.
95.
So
95.
upon the, after filing the contempt petition.
Yes, in 1995. After that order, he has not been taken back to the service. Hence, he has filed a contempt petition in CC 1017 of 1994. Where is that order of contempt?
That I have not produced it.
Produce
I
Madilla.
have produced my, ಇತ್ತಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
Thereafter, he has been taken back to the service on 6/2/1995.
ಹೌದು.
6/2/1995 as per annexure A. Since his service has not been regularized, where is that order of regularization?
ಅದೇ ಇದೆಲ್ಲನೇ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes.
Annexure
He
ಏನೆಲ್ಲ
has taken back service on 6/2/1995. His service has been regularized from 17/1/2006. Since petitioner is entitled to regularizing his service from 6/2/2005, from 2005, he has given a representation to that respondent This court, since representation has not been considered, he has approached this court in WP number 1153 of 2022. This court by order dated 1st March 2023 has directed the respondent to consider that representation submitted by the petitioner in accordance with law. Thereafter, respondent has issued an impugned endorsement annexure J, whereby request of the petitioner has been rejected. While issuing an endorsement annexure J, the respondent has not considered the order passed by this court in civil petition 79 of 1993, disposed of on 18th March 1993. Therefore, the matter requires to be remitted back to the respondent to reconsider that matter afresh. Accordingly, this petition is allowed. Order dated 15/7/2023 is quashed. The respondent is directed to reconsider that representation submitted by the petitioner dated 18/2/2022 in accordance with law, keeping in view of the earlier order passed by this court in civil petition 79 of 1993, disposed of on 18th March 1993 within 3 months from date of registered copy. Yes.
Serial number 37, Balraj AC for petitioner. Advocate.
Serial number 14, my lord.
Yes. Madam, you know who is that counsel for
He himself.
you are representing? Adelri Adyad matter.
Sir.
My lord, in serial number 30.
Serial number?
This
Serial number 14.
ಅಲ್ಲ ಅದ್ರದ್ದು
Akshata Shetty.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಬಿಡೋಣ ಅದನ್ನ. Wherever there is government has been directed to take notice, you have to mention there is a special counsel. Otherwise,
Serial number 14, Akshata Shetty.
ಬೇರೋದ್ರು ಅವ್ರಿಗೆ ಹೇಳಿ. So and so is directed to take notice for respondent number 3. Counsel for the petitioner is directed to serve one set of copies. Office is directed to show his name for respondent number 3. Yes. Next week. Copy idea. You collect the copies. Leave this matter after 2 weeks. Yes.
Lord, in serial number 37, my lord. This
Now-
honorable court sought for one order, which is not in the book, my lord. Book it is not there, my lord. That order of committee
Number
37, Balraj AC.
PF petition my lord.
yes.
That is my lord.
is managed.
Eli, when that amendment is made, mention.
2008 itself. That in that book it is not there, my lord.
Yeah, rule amendment.
At page number 2, serial number class 2, my lord. ABC, one representative from the Department of the Public Instruction.
Yes. Amendment to the.
And the other ground which is RJD is
Now, where is that page number 2?
page number 2 of that order.
Selection committee.
Selection authority
committee
means selection authority consisting of the president,
one
secretary,
subject
or a managing
experts,
committee.
one representative
subject
of the
expert
department.
nominated
Yes,
by the-
Mister.
Yes, my lord.
And the other one ground is
My lord.
other one ground is the for approval.
And under this
Beyond
rule shall be made by
45
the
days it
selection
was given.
committee. So and so qualification examination. Early the 45 days. Sir?
Beyond 45 days it is there in the statement of objection. They have given that objection. my lord.
ಅಲ್ರಿ ಎಲ್ಲ ರೂಲ್ ಅಲ್ಲಿ ಇದೆ ರೀ.
Rule 8, my lord. Rule 8.
ಕೊಡ್ರಿ ಅದು ಬುಕ್ ಕೊಡ್ರಿ.
Rule 8 is violated and for 45, my lord.
Provide education institute amendment rules 2008. ಎಲ್ಲಿಂದ ರೂಲ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ? Provide that added primary and secondary. Institution recruitment, permanent service, price provided, primary, secondary. Answer one. Rule 8.
Yes. That is the only criteria.
Rule 8.
8, my lord. If it is violative of
Rule 8.
Rule 8 seniority. Rule 8 ನಲ್ಲಿ violative ಆದ್ರೆ ನಾವು we are not.
No, 45 days ಎಲ್ಲಿದೆ ರೀ?
Annex.
Rule 8 is not to the, where it is stated that 45 days, mister.
ರೂಲ್ 6 ಅಲ್ಲಿ ಈ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲೇ ರೂಲ್ 6(3) ಕ್ಲಾಸ್ 3 ಸಬ್ಸೆಕ್ಷನ್ 3 ಮೇಲೆ ಈಗ ನೋಟಿಫಿಕೇಶನ್ ಕೊಟ್ರಲ್ಲ ಆನ್ ದಿ 2008 in that page 3 ಮೇಲೆ page 3 rule 6 sub class 3 ಅಲ್ಲಿ.
Yes, the list so prepared subject one shall be published on notice board and that copy of this shall be sent to that appropriate competent authority within 5 days from the date of fixing so and so. Yes, that is violated.
It is not so, my lord. My lord, it is incorrect, my lord. Within 9 days, my lord, the management has submitted. Kindly see page 39, my lord. Page 39. Annexure K, my lord. Annexure K, page 39. My lord, kindly see in the middle portion, my lord. Middle portion. ನಂತರದಲ್ಲಿ ದಿನಾಂಕ ಮಧ್ಯ ಇದೆ ಸರ್. ನಂತರದಲ್ಲಿ ಒಂದು ಪೇಜ್ ಒಂದು 15 ಲೈನ್ ಮಧ್ಯ ಅನುಬಂಧ 11/12 ಆದ್ಮೇಲೆ ನಂತರದಲ್ಲಿ ದಿನಾಂಕ 11/11/2011 11/5/2012 ಮತ್ತು ದಿನಾಂಕ 6/9 ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡಿರುವ ಅಭ್ಯರ್ಥಿಯ ಅನುಮೋದನೆ ಮಾಡುವ ಸಂಬಂಧ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವ ದಾಖಲೆಯಿಂದ ಕಂಡು ಬರುತ್ತದೆ. ಅದಕ್ಕೆ ಮುಂಚೆನೂ ವಿ ಹ್ಯಾವ್ ಸಬ್ಮಿಟೆಡ್ ಕೈಂಡ್ಲಿ annexure G page 32 ಮೇಲೆ
ಕೊಂಡಿರುವ ಅಭ್ಯರ್ಥಿ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದನೆ ಮಾಡುವ ಸಂಬಂಧ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವುದು ದಾಖಲಾತಿಗಳಲ್ಲಿ ಕಂಡು ಬರುತ್ತದೆ.
ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ annexure G
ಸೆಲೆಕ್ಷನ್ ಮಾಡಿರೋದು ಯಾವತ್ತು?
ಅದಕ್ಕೆ ಮುಂಚೆನೂ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದೀವಿ. ಕೈಂಡ್ಲಿ ಸಿ annexure G page 32 ಮೇಲೆ the resolution of the management.
G page
32 my lord. Resolution starting in ಓದ್ತೀನಿ. ಶಾಲೆಯ ಸಿಬ್ಬಂದಿ that is left side column, right side column ಅಲ್ಲಿ ಶಾಲೆಯ ಸಿಬ್ಬಂದಿ ಮಾದರಿ ರಚನೆಯಂತೆ ಪರಿಷ್ಠ ಜಾತಿ ಪರಿಷ್ಠ ಪಂಗಡ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ 18% ಹುದ್ದೆ ಮೀಸಲಿರಿಸಿರುವ ಸಂಬಂಧ ಈ ಹಿಂದೆ ಉಪನಿರ್ದೇಶಕರು ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ಇವರ ಪತ್ರದ ಸಂಖ್ಯೆ 3/12/2005 ಆದೇಶದಂತೆ ಶಾಲೆಯಲ್ಲಿ ಉಳಿದಿರುವ ಹುದ್ದೆಗಳನ್ನು 18% ಪರಿಷ್ಠ ಜಾತಿ ಪರಿಷ್ಠ ಪಂಗಡದ ಅಭ್ಯರ್ಥಿಗೆ ನೀಡುವಂತೆ ಆದೇಶಿಸಿದ್ದು, ಶಾಲಾ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಿದ ಆದೇಶದಲ್ಲಿ ಮುಂದಿನ ಹುದ್ದೆ ಪರಿಷ್ಠ ಜಾತಿ ಪರಿಷ್ಠ ಪಂಗಡ ಮೀಸಲಿರಿಸುವಂತೆ ಷರತ್ತು ವಿಧಿಸಿದ್ದು, ಉಳಿದ ಪರಿಷ್ಠ ಜಾತಿ ಅಭ್ಯರ್ಥಿಗೆ ವಿಜ್ಞಾನ ಶಿಕ್ಷಕ ಹುದ್ದೆಯನ್ನು ನೀಡಿದ್ದು, ಉಳಿದ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಹುದ್ದೆಯನ್ನು ನಿಯಮಾನುಸಾರ ಸಂದರ್ಶನ ನಡೆಸಿ ಸಿ ಬೋಸಯ್ಯ ದಟ್ ಇಸ್ ದಿ ಪಿಟಿಷನರ್ ಮೈ ಲಾರ್ಡ್ ಕಲಾ ಶಿಕ್ಷಕ BA B.Ed ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಾಗಿ ಇವರನ್ನು ಸಂದರ್ಶನ ದಿನಾಂಕ 30/10/2009 ನಡೆಸಿದ್ದು, ಆಯ್ಕೆ ಮಾಡಿದ ಅಭ್ಯರ್ಥಿಯ ಅನುಮೋದನೆ ಪ್ರಸ್ತಾವನೆ ದಿನಾಂಕ 18/11/2009 ದಟ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ ವಿತಿನ್ 40 to 45 days ಮೈ ಲಾರ್ಡ್. ಮತ್ತೆ 18
ಕಳಿಸಿರೋದಕ್ಕೆ ಎಲ್ಲಿದೆ?
ಕಳಿಸಿದ್ದಾರೆ.
ಅಲ್ಲ ಏನ್ ದಾಖಲಾತಿ ಏನಿದೆ ನೀವು ಹೇಳಬಹುದಲ್ಲ.
ಹೌದು.
What is the material to show that it has been sent, Mr.?
My lord, in the kind of annexure, that is a representation to block education officer. Adalla now the management stay.
ಆಯ್ತು ಹೇಳಿದೀರಾ, where is that?
ಅದಲ್ಲೂ ಹೇಳ್ತಾರೆ 18/11/2009ಕ್ಕೆ. ಮಲ್ಲಡ್ all the documents ಅವ್ರ ಹತ್ರ ಇದೆ ಸ್ವಾಮಿ.
ನೀವು ಕನ್ಸಿಡರ್ ಎಕ್ನಾಲಜ್ಮೆಂಟ್ ಏನಿದೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ನಾವು how can you prove that?
Then I will.
Statement ನಲ್ಲಿ ಕೊಟ್ಟಿರುವಂತ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲೂ ಸಮೇತ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮೇಡ್ ಆನ್ 2/11/2009.
ಹೌದು 18.
Submitted first proposal only on 18/11/2009, but it is not in accordance with the format of 45 days.
ಈಗ format
ನಲ್ಲಿ produce
2/11/2009 appointment.
Yes madam.
ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ?
18/11/2009 ಅಂತಾನೆ ನಮ್ದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ನೀವ್ ಎಲ್ಲಿ ಓದ್ತಾ ಇದೀರಾ?
ಅವ್ರ ಫಾರ್ಮೆಟ್
ಇದ್ರಲ್ಲಿ 37 ನಲ್ಲೂ ಹೇಳ್ತಾರೆ. 37 ನಮ್ಮ ಅಧಿಕಾರಿ ಹೇಳಿದ್ದಾರೆ. Even current return statement ನಲ್ಲೂ statement of
ನಿಮ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇರ್ಲಿ, ಇದ್ರಲ್ಲಿ ನಿಮ್ ಯಾರು BO ಹೇಳದ?
BO
ಎಲ್ಲಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದ್ರಿ?
ಇಲ್ಲ ಇನ್ನು ಮಲಡ್ page 37 one Malad, page 37 may kindly be seen, Malad. That is the opinion, recommendation of the block education officer. Last para, column 19, Malad, para 19. Abhipraya. ಸದರಿ ಶಾಲೆಯು ಗ್ರಾಮಾಂತರ ಮಕ್ಕಳಿಗೆ ಉತ್ತಮ ಗುಣಮಟ್ಟದ ಶಿಕ್ಷಣ ನೀಡುತ್ತಿದ್ದು, ಶಾಲೆಗೆ ಅವಶ್ಯಕವಾದ ಎಲ್ಲ ಮೂಲಭೂತ ಸೌಲಭ್ಯಗಳು ಹೊಂದಿರುವುದರಿಂದ ಸದರಿಯವರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಉಪನಿರ್ದೇಶಕರ ಕಚೇರಿ ಸೋನ್ಸೋ ಪತ್ರ ದಿನಾಂಕ 3/12/2005 ಅನ್ವಯ ಸಿಬ್ಬಂದಿ ಮಾದರಿ ರಚನೆಯಂತೆ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಗುಂಪಿಗೆ 18% ಹುದ್ದೆ ತುಂಬುವ ಸಂಬಂಧ ಇವರನ್ನು ನಿಯಮಾನುಸಾರ ಶ್ರೀ ಬೋಸಯ್ಯ ಕಲಾ ಶಿಕ್ಷಕ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಬ್ಯಾಕ್ಲಾಗ್ ಇವರನ್ನು ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ನಂತರ ಸದರಿಯವರ ಪ್ರಸ್ತಾವನೆ ಅನುಮೋದನೆಗಾಗಿ ದಿನಾಂಕ 18/11/2019 ಇಲ್ಲೂ ಹೇಳ್ತಿದ್ದಾರೆ ಸರ್.
ಹಿಂಬರ ಬಂದಿರುತ್ತದೆ
17/9/11 ಮತ್ತು 5/1/2 ಹಿಂಬರ ಬಂದಿರುತ್ತದೆ. That is my lord, they have submitted the ಈ ಹುದ್ದೆಯಲ್ಲಿ ಈ ಹಿಂದೆ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಸದರಿಯವರು ಚಿಕ್ಕಲಿಂಗ ಅವರ ಹುದ್ದೆ ಅನುಮೋದಿಸುವ ಸಂಬಂಧ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅಂಚಿಸುವ ದಿನಾಂಕ
16/11/2009 ಬಂದಿದೆಯಲ್ಲ?
ಬಂದಿದೆ.
But there is no representative of.
My lord, I cannot be responsible. My lord, ಇಲ್ಲ ಏನಾಗುತ್ತೆ my lord, the management also have promptly submitted the representation request. My lord,
management has to appoint you after that representation, otherwise management is liable, they will pay that.
ಇಲ್ಲ they have requested my lord, ಇದು ಇವರು ಪ್ರಪೋಸಲ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. kindly see page 39 ಮಾರ್ನಿಂಗ್. ಇಲ್ಲ ಬೆಳಿಗ್ಗೆ ಓದಿದೆ my lord,
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದಾಗ
ಅವ್ರು ಕಳಿಸ್ಲಿಲ್ಲ
ಅಂತ ಅಂದ್ರೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವ್ರು ಮಾಡ್ಬೋದು ಅಂತ ಎಲ್ಲಿದೆ ಕಾನೂನು?
my lord, ಅವ್ರು ಯಾವತ್ತೂ ಕಳ್ಸಲ್ಲ ಸಮಾಲಿ.
ಕಳಿಸ್ಲಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ they can be
I cannot be. My lord, I cannot
no,
be.
You cannot be. You can claim against the management.
My post, my lord, still, my lord, it is not approved, my lord. 18 years I have put in service, my lord.
I can't direct that to approve contrary to the law, Mr.
My lord, consider, my lord, in one of the judgment, division bench judgment, my lord, it kindly see para 9 and
on what point?
That point, my lord, where is the suppose irregular appointment idre, if there is an appointment irregularities idre, atal my lord, it kindly para 9 and 10, my lord.
If appointment is not in terms of the law,
my lord,
how can be approved? You show that any judgment, then I can consider that.
Please, man. In so far as the other contention relating to illegality and the selection process, my lord, as noticed in the audit objection, the order of approval of appointment of the petitioner in terms of the order at Annexure D would make it clear that the Director of Technical Education has regularized the appointment as the one-time measure, which is clear from a reading of the order of approval appointment dated 14/11/2006. The validity of such approval has not been called in question for a period of about 12 years from the date of approval. During such time, it is stated that the petitioner has not only enjoyed service in the institution, but services were also lent to the government, which is a matter of record. Further, it must be noticed that the order of approval of the appointment at Annexure D would make it clear that the order of approval was a one-time measure subject to condition that this having been made by the Director of Technical Education. The state cannot at this point of time, after more than 12 years, turn around to contend that the selection process being illegal. Approved as a one time approval ಆಮೇಲೆ ತಪ್ಪ approval is
approve ಆಗಿ 12 years ಆದ್ಮೇಲೆ they have discharged, they said it cannot be. ನಿಮ್ದು approve
ಇಲ್ಲ ಆಮೇಲೆ kindly see para 10 ನಲ್ಲಿ
ಅಷ್ಟೇ ಅದು
It is clarified that relief being granted to the petition in the light of discussion made above, it is not to be considered the court has overlooked the utterance to correct procedure in appointment.
Yes, yes, that is not applicable, yes.
My lord, no, my lord, as per their own proposals, my lord, I am eligible for appointment, my lord.
No, that
I have-
management has to, if
I-
management has made a fault, then they will pay that.
My lord, now,
Liberty is reserved to,
no, I'll, with regard to salary, my lord, others, my lord, now, my lord, at least from this day, my lord, let them consider reconsider my appointment for,
your appointment itself is wrong. How can that now?
my lord, there is, my lord, wrong in the sense, my lord.
Rules ಎಲ್ಲ ಯಾಕೆ ಮಾಡ್ಬೇಕಾದ್ರೆ?
My lord, wrong in the sense, my lord, the department nominee was not there. That is the only issue, my lord.
Show me any law saying that without the nominee of that government, if appointment is considered, it can be approved.
Well, I'll look into that, my lord, then.
This is what that, when I put the question, you will say that I will look into.
ಇಲ್ಲ ಅದನ್ನ ನೋಡ್ಬೇಕಾದ್ ಯಾವ್ದಾದ್ರು ಜಜ್ಮೆಂಟ್ ಏನಾದ್ರು ಎಕ್ಸೆಂಪ್ಷನ್ ಕೊಟ್ಟಿದಾರ ಅಂತ.
ರೂಲ್ಸ್ ಇದ್ದಾಗ ಮತ್ತೆ ರೂಲ್ ಯಾಕೆ ಮಾಡ್ಬೇಕು?
ಇಲ್ಲ ಸಪೋಸ್ ಈಗ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಾಮಿನಿನೇ ಹೋಗ್ತಿರೋದು ಅವ್ರ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ನ ಹಂಗೆ ಇಟ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳೋದು.
That is for the management to seek for a nominee, otherwise they have to take the recourses available under the law. They can't do it their own. ಸುಮ್ಮನೆ ಲೆಟರ್ ಬರ್ಬಿಟ್ಟು ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇವ್ರೇ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ then what is the purpose of making?
ಇಲ್ಲ at least my lord, when the proposal, my lord, at least when the proposal was submitted, they should have issued an endorsement saying that appointment is irregular. They won't say, my lord, after 18 years, my lord, now these endorsement has
No,
been
they are
issued.
not, see, it is the fault of the management. Management will-
ಇಲ್ಲ ಅವ್ರು ಅವಾಗ ಏನ್ ಹೇಳಿದ
Page number 45 annexure P. The right for interview is only reserved for the applicant who has applied in 2009, my lord. The interview will be conducted only for the persons who have applied in 2009 itself, my lord.
ಮಾಡ್ಲಿ ಹಂಗೆ
Among, that is what annexure P shows.
ಮಾಡ್ಲಿ ಸ್ವಾಮಿ ಹಂಗ್ ಮಾಡಿದ್ರೆ ಲೆಟ್
ಏನು ಮಾಡಕ್ ಬರಲ್ಲ. Dismiss ಒಂದೇ ಮಾಡಬಹುದು. If you show any judgment to show that this lacuna can be cured, I will consider. Otherwise, I think last ಇದರಲ್ಲಿ ರೋಸ್ಟರ್ ಪಾಯಿಂಟ್ ಅಲ್ಲೇ ನಾನು ಕಳಿಸಿಲ್ಲ ಆ ರೋಸ್ಟರ್ ತಪ್ಪಿಸ್ಕೊಂಡ್ರೆ ಈಗ
ಇಲ್ಲ ಇಲ್ಲ ಅವ್ರಿಗೆ ಎಸ್ಒ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ದು.
Now we'll fix that time.
Please,
yes. On 29th.
Please,
show, otherwise I will dismiss it. You go and claim against the management, Mr.
ಇಲ್ಲ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವ್ರದ್ದೇನು ತಪ್ಪಿಲ್ಲ.
ಹಂಗ ನೀವು ವೆರಿ ಕ್ಲೋಸ್ ವಿತ್ ದ ಮ್ಯಾನೇಜ್ಮೆಂಟ್.
ಇಲ್ಲ ಅವ್ರು ನಮಗೆ ಸಪೋರ್ಟ್ ಮಾಡ್ತಾರೆ.
Yes, yes.
List continuation, cell number 43, Anand B for petitioner. Nagarajappa.
46,
I challenge the annexure K, my lord.
Yes.
Really, the petitioner husband serving as a supervisor at library, Gujinadu village.
Yes.
He was died on 12/1/2022 during COVID-19.
12/1/2022. Yes.
Thereafter, the panchayat decided quorum and give an appointment for petitioner as a worker. Kindly see the annexure H, my lord. Hajarati, Sarvajanika Granthalaya Ilake. 27, page number 27. ಅದರಲ್ಲಿ ಚಂದ್ರಕಲಾ ಅಂತ ಇದೆ. Page number 27 ಮೇಲೆ.
No, where is Nagarajappa?
ಅಲ್ಲ, they given a copy, they already appointed, but before appointing, already filed an application. My application is pending consideration. She is a widow. After the death of her husband, she unable to live a happy life because she having a school going children.
Where is Nagarajappa? He has to answer.
Morning idlu.
I think first session, my lord, he mentioned that my lord, already the post has been filled. And he told that he will file it.
Post is violating the, because kindly see my page number 17, my lord, annexure B.
Oh, this is the case where he is mentioning.
Yes.
ಎಲ್ಲಿ ಅದು ಕಾಪಿ ಎಲ್ಲಿ ಅದು?
He told that he will file it.
ನಮಗೆ ಕೊಟ್ರು.
ಅದನ್ನ leave this matter on Tuesday, Wednesday, next Wednesday. Let us see.
Yes. During, I already filed an application without considering the widow application on compensatory ground.
Yes.
They selected.
Yes, we'll hear.
It's violating.
Yes, 22nd. Yes.
Cell number 44 adjourned, cell number 45, Nayak Venkatraman for petitioner, H. Chandrachud.
Annexure E.
Seek for small accommodation. I've just sent it for comments. Bandide.
What is that annexure E?
Annexure is the place under suspension. It's passed under 18/1/2025. Pending
18/1/2025.
2025.
25.
25.
6 months ಆಯ್ತಲ್ಲ, is it same rule is in which under which provision you have been kept under suspension?
Under
Which is that?
Under 8 of the KPTCL.
ಎಲ್ಲಿದೆ ಕೊಡಿ ರೂಲ್ ಕೊಡಿ.
ಆರ್ಡರ್ ನಲ್ಲಿ ಏನೋ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ.
ಆರ್ಡರ್ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ, ಬಟ್
ಆಯ್ತು, which is the power which you have exercised that? ಕೊಡಿ.
ಅದಕ್ಕೋಸ್ಕರ I just sought for instruction.
ಆಯ್ತು, ಸಸ್ಪೆನ್ಷನ್ ಯಾವ ಪವರ್ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು either petitioner counsel should know or you have to say.
ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ with the particular provision of law which has been invoked is very silent, Your Honor. That's the reason why I have just sought information under which provision of law it was.
Where is that?
Rule 8.
Rule 8. Suspension. The appointing authority to which he is subordinate may authority to empower any corporation in this place where a disciplinary proceeding against him completed is pending, where the case against him is provided where the order of the suspension is made by the competent in this behalf of authority which authority shall, the circumstance and the order made, the person shall be deemed to have been placed upon the suspension, detains, custody, so on period of social where the penalty dismissal, removal, and appeal is reviewed, is dismissal, and the effect of the convictions also. Deemed to have been made under this section to continue remaining for till it is notified revoked by. So when the corporation employees suspended is deemed to have been commenced against him during the continuous suspension. ಆಯ್ತು, 5C ಕೆಳಗಡೆ there is a provision for revocation. You given a representation, let him consider.
Made a representation for revocation of suspension. On 4/3.
You consider that will dispose of.
They have not considered. It's for pending.
Any order of suspension made or deemed to have been made under this regulation at any time by modified or revoked by the authority which made or deemed to have been made order by authority to which authority is subordinate. If you want, you consider that if you are not initiated till inquiry, you consider that and dispose of.
Maybe one small accommodation to Tuesday or something. ಯಾಕಂದ್ರೆ ರಜಾ ಇರ್ತಾರೆ, I will also be out of town. Maybe Tuesday, if your lordship takes up this matter, in that time I would have called them to my office, find out, and I'll make my submission to that aspect.
Where is your representation?
Annexure ಆಗಿದೆಯಾ?
After pending of
Then I will direct that you dispose of. Otherwise we
ಕೊಟ್ಟಿದಾರ ಇಲ್ವಾ ಅಂತ at least
ಕೊಟ್ಟಿದ್ದಾರೆ. See, otherwise in view of Supreme Court judgment.
Yes, I bow down to that particular aspect.
Before that,
within 6 months,
yes,
if you are not
this is a better
started
way that you have to, yes.
only on a smaller note, maybe because instructions, it would be wrong on my part to make it. Tuesday, my lord, without any fail, that day I will just assist
I
the
will
court.
not record that you have made submission. I will.
Judicial order.
Judicial order. Yes. This writ petition, petitioner called in question. Annexure
E.
Annexure E dated 18 January 2025 passed by which respondent?
ಅಂದ್ರೆ ಕೆಲವೊಂದು photographs ಗಳು ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದಾರೆ ನನಗೆ instruction ಜೊತೆಗೆ. There is some gross irregularity by the.
We are not saying that you
ತೋಟದಲ್ಲಿ ಲೈನ್ಗಳನ್ನೆಲ್ಲ.
If the inquiry is not initiated, you can revoke it and post it in some other places. You can conduct an inquiry. Otherwise, you are paying a salary. That is that intention where that 6 months period has been fixed. Otherwise, he is getting in a public money without work.
But sitting.
Yes, that's what that. 18 January 2025, passed by respondent number 3, wherein petitioner has been kept under suspension by invoking regulation Karnataka Power Transmission Corporation Limited, Karnataka employees KEB Employees Classification, Disciplinary Control, Appeal and Regulations, 1987. Same is applicable. Same rule.
But in the order that has not been taken.
No, order mentioned.
Rules, that is the appointing authority is empowered to conduct.
No, this is the rule.
Yes,
not
ma'am.
KEB
rules.
Classification Control. Yes. By invoking the Regulation 8 of 1987, petitioner has been kept under suspension. Petitioner has joined the service with Bangalore Electricity Supply Company Limited as a junior meter reader on 17/3/2008. Thereafter, he was been promoted as a overseer on 27/9/2013. Now you are working as what?
He's working as overseer.
When he was in service, on what are the allegations?
The allegations, madam, page number 29.
ಈಗಾಗಲೇ ಯೋಜನೆ ವಿದ್ಯುತ್ ಮೂಲಭೂತ ಸೌಕರ್ಯ ಸಾರ ಸಂಖ್ಯೆಗಳಿಗೆ ಅಂದಾಜು ಪಟ್ಟ ತಯಾರಿಸಿ ಸಲ್ಲಿಸುವ ಮೂಲಕ on some allegation he has been kept under suspension by impugn order annexure V dated 18 June 2025. Being agreed by the same, the petitioner is before this court. ಏನ್ ಇವತ್ತಿನವರೆಗೂ ಎನ್ಕ್ವೈರಿ ಇನಿಷಿಯೇಟ್ ಮಾಡಿಲ್ವಾ? Learned counsel appearing for the petitioner submitted that even today the departmental inquiry has not been initiated. Therefore, petitioner has submitted a representation on 4/3/2025 seeking for revocation of the suspension order. Respondent has not passed any order. Under these circumstances, without expressing any opinion on the merit of the case, the respondent, which respondent has to consider? 3, respondent number 3 is directed to consider that representation of the petitioner void annex representation dated 4/3/2025 in accordance with law, not later than 4 weeks from date of receipt of the copy of this order. Yes.
Reinstatement.
ಅವರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ. They are paying this. See, if they say yes, inquiry may be delayed, will be reinstated. Other they will be dismissed. Then you can challenge that. Then we can hear. Yes. All the contentions of the parties are left open because again, if you challenge, this contention will be there. Yes.
Serial number 46 GT Kumar for petitioner. Patil JM.
Petition.
Yes.
My lord, the petitioner is
Kodi.
senior citizen and retired from the service by tendering the resignation, madam, in 2001. The petitioner was working as a manager and in first respondent department. By tendering the resignation, he got retired from the service and he has rendered 23 years and he has completed 20 years of qualifying service.
Yes.
And he has claimed the pension, my lord. As per annexure C, 25 page 20 page.
Now what is that impugn order?
Impugned order is annexure V, my lord. They have denied to extend the pension, though there is a recommendation from the IBA, first respondent, as well as the central government has
Page
approved.
annexure V.
Annexure V, page number.
Yes, read.
Page number 110, my lord.
Read.
This has reference to your representation cited first above, requesting to cover you under the bank's pension scheme and to extend pensionary benefits consequent to your resignation from the service of the bank on 28/2/2001 and the order of the Honorable High Court referred to above. Following the industry level settlement dated 8/3/2024, Indian Banks Association Circular so 3/9/2024 advised all the private sector banks that Member bank, if they decide so, may consider extend an option of pension to the resignee who were otherwise eligible to join the pension scheme under the Bank Employees Pension Regulation 1995 at their end. In the light of the above, you may note that the bank has decided not to extend the pension option to resigned employees. Thus, we express our inability to consider your request and your advice
Yes,
accordingly.
for resigned employee, there is no pension scheme.
No, my lord.
My
My lord, automatically he is not benefited by this, my lord. Your lordship may kindly see
Where is
109
that
annexure
scheme?
U.
Where is that scheme?
Annexure
Scheme,
U,
yes,
my lord.
One second. Annexure. Annexure C. Annexure C is the joint note, my lord, entered to between the bank, my lord.
Where is that? Even
Yes, ma'am.
resigned employee is also entitled
Yes,
for
yes.
the pension.
Page 53, my lord. Page 53.
Yes.
Even Supreme High Court judgment where it says that an employee who has completed 20 years of qualifying service is entitled for the
No, in
pension,
respect
ma'am.
of the bank.
Yes, my lord. 53, my lord.
50?
53.
53.
Para 14, my lord. Option for resigned employees to join pension scheme, my lord.
Yes.
In terms of the memorandum of understanding arrived at between the parties wide MOU dated 7th November 23, it is agreed, subject to approval of the government, that the employees who were in service of the bank on or after 1/1/1986 and had joined the banks before 1/4/2010 and who have resigned from the service of the bank on or before 26/14 and who are otherwise eligible to join the pension scheme while in service will be given an option and opportunity to join the pension in the scheme following terms, my lord. The following categories that so based on this approval of the central government, my lord,
No, when did you resign?
I entered into service in July 1977. ಈ ಕಂಡೀಷನ್ ಏನ್ ಹಾಕಿದ್ದಾರೆ ಆಲ್ ವಿಲ್ ಬಿ ಐ ಆಮ್ ಕಂಪ್ಲೈಂಗ್ ವಿತ್ ಆಲ್ ದಿ ಕಂಡೀಷನ್. July 77, madam.
77.
And tendered the resignation on 28/2/2001, madam.
2001.
Yes, this
yes.
condition I am complying with that.
Yes.
So subject to approval of the government, central government. Central government have approved, my lord, annexure D. Annexure D, page 75. Dated 16th March 2024, my lord, to the Chief Executive, Indian Bank Association, World Trade Association. That para 3, my lord, below, ಕೆಳಗಡೆ, it is further stated that all such eligible former employers, officers, resignees, and their surviving spouses or eligible family members can join the pension scheme subject to the following condition. The pension will be paid prospectively from the month of following the month in which the bank received the bank's contribution towards the provident fund received by the former employees, former officer at the time of resignation or later. The commutation of pension will not be extended to them and they will not demand. Pension shall be commuted as per the applicable provisions of the pension regulation as applicable to the relevant bipartite settlement joint note. This was entered, approved during the pendency of the writ petition filed by me bearing WP number 881 of 2013. That petition, annexure R, my lord. Annexure R nalli I submitted, in the sense during the pendency of the writ petition, this event transpired, my lord. And this event I brought to the knowledge of the Honorable Court. And Honorable High Court, by considering all the relevant facts which I have narrated, my lord, have produced all the joint note approval of the central government. By considering that, the writ petition was disposed with a direction, that is page number 98, my lord, operative portion.
Yes.
In that view of the matter, without expressing any opinion on the merits of the claim of the petitioner, the respondents are directed to consider the case of the petitioner for enrolling him in the pension scheme by considering his representation dated 6/6/2024. Having regard to the fact that the petitioner retired in the year 2001, consideration of the representation of the petitioner shall be done as early as possible, at any rate within a period of 3 months from the date of receipt. I submitted the representation, and without proper consideration of the representation, they have issued the cryptic impugned order, a non-speaking order, without assigning any reason. That is annexure B, my lord. And as per annexure U, second respondent have issued the letter recommending the banks
Annexure U.
decide at their end. Annexure U, my lord. Annexure U ಅಲ್ಲಿ ಎಲ್ಲ ಬ್ಯಾಂಕ್ಗೂ ಕೊಡ್ತಾರೆ. All private sector and foreign banks which are signatory to settlement.
Annexure U, page
109, my lord.
Yes.
Second parameter, member banks, if they decide so, may consider extend an option of pension to the resignees who are otherwise eligible to join the pension scheme under the bank employee pension regulation and at their end. This is a recommendation given by the second respondent as per the note. Joint note as per annexure C, there is a clear mention that IBA second respondent shall recommend. That is
Subject to the approval.
page number. Page number 26, my lord. Annexure C. Annexure C, page 26, bottom, my lord. May I read it?
Now,
my
when did you join that bank?
lord? Bank, I joined the bank in the July 1977, my lord.
See, the employee who are in the service of the bank on or after 1/1/1986, none you are in the service.
Yes, my lord.
I joined the bank before 1/4/2010. You are
Yes,
joined before that.
Yes,
And who are resigned from that service of the bank on or before 26/4/2010.
Yes, my lord.
You have resigned in 2021.
No, 2001, my lord.
2001.
Yes. 28 to 2001, my lord. So ಅಲ್ಲಿಗೆ 23 ವರ್ಷ ಸರ್ವಿಸ್ ಆಗುತ್ತೆ. ಕ್ವಾಲಿಫೈಯಿಂಗ್
Yes.
ಸರ್ವಿಸ್ 20 years ಆಗುತ್ತೆ.
Who are otherwise eligible to join the pension scheme while in the service will be given an options and opportunity to join the pension scheme on the following terms and conditions. Yes, madam.
My lord, everything my learned friend has argued, my lord, there is no, ಇದು annexure U ಪ್ರಕಾರ ನಮಗೆ we may consider, it is not a directory provision. Shall ಅಂತ use the option has been given to the banks.
Where is that?
Your lordship may kindly see annexure U 109. For schedule, only SBI it is compulsory. Schedule banks it is at the end of the banks, they can decide whether they have to consider.
Now, where will you get that?
Your lordship may kindly see at annexure U in page 109. Second para.
Yes.
Member banks, if they decide so, may consider extending an option of pension to the resignees who were otherwise eligible to join the pension scheme under the Bank Employees Pension Regulations 1995 at their end.
Yes.
Option has been given to the banks. It is not automatically just because he has completed 23
No, in
years.
terms of that, this scheme, it is not applicable to him.
No, my lord, not for the schedule banks.
No, this is not applicable to scheduled
Schedule
banks.
banks, they have given an option. This has been issued after that joint note.
Where will you get that? You have given an option.
ಇದರಲ್ಲಿ ನಮಗೆ ಅದಾದ್ಮೇಲೆ ಇದು annexure.
You forget about that letter. It is letter written by that some senior advisor. Where is the rule which says that it is
Lord,
an
Indian
option?
Banks Association ಅವರು ಕೊಟ್ಟಿರೋದು option because the joint note is between the Indian Banks Association
No,
and employees.
This salary pension, 9th joint note.
Joint note, my lord.
Yes, it is not applicable to you.
No, my lord, option has been given for us.
Is applicable because this bank is also one of the signatory. Page 61, my lord, page 61.
Indian Bank Association, Zones Officers Association joint note.
Page 61 ಅಲ್ಲಿ ಸ್ವಾಮಿ annexure 2 ಅಂತ ಇದೆ. ಫೆಡರಲ್ ಬ್ಯಾಂಕ್ ಅಂತ ಇದೆ. They are also signatory to this joint note.
Yes.
Lord, 1995 scheme ಅಲ್ಲಿ who was eligible for the pension, we have to consider. My lord, there is a clause in 1995 scheme.
Where is that?
My lord, that I have not produced it here, my lord. Earlier writ petition, I had filed my objection. Along with that, I had produced.
Now, new latest joint note has come, my lord. That is annexure C ಪ್ರಕಾರ latest joint note ಪ್ರಕಾರ ನಾವು ಕ್ಲೇಮ್ ಮಾಡ್ತಿರೋದು. Earlier joint note ಪ್ರಕಾರ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಅದನ್ನ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ರು. ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ನಾನು ಕ್ಲೇಮ್ ಮಾಡಿದೆ, ಅದನ್ನ ಡಿನೈ ಮಾಡಿದ್ರು.
No, that you will see employee pension regulation 1995. What it
1995, I'll produce it.
You produce that. You give that copy. When you are
ಇದರಲ್ಲಿ
relying on
ಏನು
that,
ನಮಗೆ joint note ಅಲ್ಲಿ directly there is no, it is not binding on all the banks. Only the SBI has opted for that.
No, but
My
why
lord.
you have signatory to that?
My lord, signatory, but it is as per the 1995 rules, we have to consider.
No, as
That is
per the joint
sir,
note.
let me
annexure.
complete my
Yes, ma'am.
argument.
Yes.
Sir, my lord, as per annexure U, the option has been given to the scheduled banks. My lord, the who were otherwise eligible to join the pension scheme under the Bank Employees Pension Regulations 1995 at their end. They have specifically mentioned, my lord.
No, see, this is in a letter.
My lord, it has been given by the Indian Banks
No,
Association.
if they given a letter, it's in a law.
My lord, this
It
is
should be based upon the law. If that some senior advisor has given.
after the joint note, it has been issued to all the scheduled banks by the Indian Banks Association. Because joint note only, it is not binding directly on the scheduled banks.
Is it
Only the government banks, it has been binding on the government
where
banks.
it is stated? That's what I want to know, madam. I can't accept what you are saying unless it is there in that written.
The joint note alone in direct all the banks, it is idu anta enilla. Very vaguely they have contained it, my lord.
What is that
Option for the resigned employees to join pension scheme. In terms of the memorandum of understanding arrived at between the parties wide MOU dated 7th November 2023. It is agreed subject to the approval of the government that employees who were in service of the banks on or after 1/1/1996 and had joined the banks before 1/4/2010 and who were resigned from the
Amendment
service of the banks.
Annexure A and Annexure 1 and 2 elidari.
Annexure.
That.
That it's a 61, page 61, my lord.
Ninth joint note.
How the joint memo there, it's a part of joint memo, my lord.
Annexure 1 and Annexure 2.
Yes, my lord, 61, page
My
61.
lord, I am not disputing that. I am also party to this joint note, my lord, wherein the 1995 regulations, it has specifically states that resign ಮಾಡಿರೋರಿಗೆ ಏನ್ apply ಆಗುತ್ತೆ?
What do you have
Voluntary
you
retirement,
give
my lord,
that
that I'll produce it in
You
the
got
state.
give that rules.
No,
Yes.
in
Voluntary retirement ತಗೊಂಡಿರೋರಿಗೆ ಏನಾಗುತ್ತೆ ಅಂತ?
Let us see that rules.
Please, my lord.
Yes.
My lord, in impugned order, what they have given, my lord, they themselves clearly state that para second may be.
No, they are relying on that.
No,
Some letter which is given, they have stated that it is option for you. They said that we are not opted you. Is it the law? I want to know that, mister.
I mean 1995 ರೂಲ್ಸ್ ಪ್ರಕಾರ ಇದು ಮಾಡೋದಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡೋದಕ್ಕೆ ಆಪ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲಿ impugned order may be ಒಂದೇ ಸತಿ ನಾನು ಒಂದು ಸತಿ page 110.
Yes.
Para second para, my lord. Following the industry level settlement dated 8/3/2024 Indian Banks Association circular dated so 3/9/2024 ಪ್ರಕಾರ ಇವ್ರು ಹೇಳ್ತಾರೆ, ನಾವು ಹೇಳ್ತಿರೋದು 24 ಪ್ರಕಾರ ಇವರೇ ಕೇಳ್ತಿದ್ದಾರೆ ಕೊಡೋದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದೆ.
ಎಲ್ಲಿದೆ ಆ ಸರ್ಕ್ಯುಲರ್ಗಳು?
ಆ ಸರ್ಕ್ಯುಲರ್ ಅದೇ that itself is 3/9/2004 annexure C, my lord ಬರುತ್ತೆ. Annexure C
8/3/2024.
Yes, my lord. Annexure C ಅದೇ ಜಾಯಿಂಟ್ ನೋಟ್ ಸ್ವಾಮಿ. ಆ ಜಾಯಿಂಟ್ ನೋಟ್ ಪ್ರಕಾರನೇ ನಾವು ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳೋದು. ಅವರೇ ಹೇಳ್ತಾರೆ themselves 95 ಹೋಗೋದಿಲ್ಲ ಅವರು.
Consider extending that. See, is there any where it is stated that this is an option for the bank? They are saying that this joint note
ನಲ್ಲಿ one submission, my lord. ಜಾಯಿಂಟ್ ನೋಟ್ ನಲ್ಲಿ IBA shall ಅಂತ ಹೇಳ್ತಾರೆ.
ಎಲ್ಲಿದೆ?
Annexure C my lord, page 26.
Retired thereafter, but
Page
before the
26,
date of
my lord.
settlement was opted for page
26. Page 26 joint note start ಆಗೋದು 26, my lord. Annexure C. Annexure C 25 joint note ಅದು. ಇಲ್ಲಿ page 26 salary revision for officer with effect from 1/1/2022. Bottom line, Swami. Indian IBA shall recommend to the private sector banks which are listed in Annexure 2. Annexure 2 ನಲ್ಲಿ ಈ ಬ್ಯಾಂಕ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. And which have authorized IBA in this regard to give effect to the salary revision on some lines as mentioned in joint note and other monetary, non-monetary benefits as detailed under the various annexures. Next 27 then page 27.
benefit under sound so.
ಅವರೇ ರೆಕಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. They themselves has recommended. Annexure B ಇವ್ರು ಏನ್ ರೆಫರ್ ಮಾಡ್ತಿದ್ದಾರೆ IBA ಅವರೇ ರೆಕಮೆಂಡ್ ಮಾಡಿರೋದು.
Yes.
Discretion has been misused, my lord. It is misinterpreted to their own convenience. ಅವ್ರು ಹೇಳಿದಾರೆ ನಾವು ಕೊಡಕ್ ಬರೋದಿಲ್ಲ, ನಮ್ಗೆ ಫೈನಾನ್ಷಿಯಲ್ ಕೆಪಾಸಿಟಿ ಇದೆ ನಾವು ಕೊಡ್ತೀರಿ. ಬ್ಯಾಂಕ್ ಇಸ್ ಗೋಯಿಂಗ್ ಇನ್ ಪ್ರಾಫಿಟ್ ಮೈ ಲಾರ್ಡ್, ಹ್ಯೂಜ್ ಪ್ರಾಫಿಟ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದೆ. ಬೇರೆಯವರು ಕೊಡ್ತಿದ್ದಾರೆ, ನಾನೊಬ್ಬನಿಗೆ ಡಿನೈ ಮಾಡ್ತಿದ್ದಾರೆ.
Where is that it is given to that others?
This is the document, my lord.
Fixed pension payable. Professional.
One sir. Financial.
No, you have opted for this scheme.
Yes.
Where is that?
Lord, first he'll receive all the benefits on the day of
No, no,
resignation.
See, you see that condition number 1 in page 53.
53.
Yes.
The following categories of former employees who satisfy all the conditions stated in subclass A to C. Complaint ಮಾಡಿದ್ದೀರಾ? It's been complained by.
Give me that. See, they said within 90 days.
Refer ಮಾಡಿದಲ್ಲ, ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ರೆಫರ್ ಮಾಡಿದ್ರು. ಅವರ ಡಿನೈಡ್ ಲೆಟರ್ ನಲ್ಲಿ
Within 90 days of the announcement of such an options as a one-time measures only.
Yes, sir.
Where is that?
ಅಲ್ಲ, ಆಪ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಮೈ ಲಾರ್ಡ್. ಆಕ್ಚುಲ್ ಆಗಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇತ್ತು, ಆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ಕೊಟ್ಟೆ. ಅಷ್ಟರಲ್ಲಿ ಅವರೊಂದು IBI ಲೆಟರ್ ತಗೊಂಡು ಯು ಆರ್ ನಾಟ್ ಎಲಿಜಿಬಲ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಪ್ಷನ್ ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವರು ಇನ್ನೂ.
When this scheme has come,
it has not been announced by the bank.
No, they are not said that they have bank has to be announced. They said that you have to be opted for within 90 days, whether you opted it or not.
881 ಪಿಟಿಷನ್ 881 ನಲ್ಲಿ ಕೋರ್ಟ್ ಅಲೋ ಮಾಡಿದೆ ನನ್ನ ಪಿಟಿಷನ್ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ. ಅದರ ಪ್ರಕಾರ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ. ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes, we will argue that. Yes.
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದು ರಿಟ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇರಬೇಕಾದ್ರೆ
ಕೊಡಬೇಕಂತಿಲ್ಲ. ಕೋರ್ಟ್ said consider in accordance with law. Now to claim this, first thing is that there should be an option within 90 days from the date of that announcement.
But
that is an option as one time measures only. They have not announced that options. You are not
My lord, this is 1995 ಏನು regulation, pension regulation scheme ಬಂದಾಗ one more option was given to the employees to join the benefit of the pension scheme. ಆವಾಗ he will not opt for that. ಆಮೇಲೆ like ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗುತ್ತೆ, then he'll come and file a writ petition.
Madam, I am not on that. See, in this scheme itself,
option
they have said that as in one time measures, person who is already appointed, who has not given under 99 options, they have given a one time measures within 90 days, they have to give an options.
Option you open ಮಾಡಿದ್ದ ಅಂದ್ರೆ ನಾನು ಕೊಡ್ತಾ ಇದ್ದೆ, ಅದು ಆಪ್ಷನ್ ಓಪನ್ ಮಾಡಿಲ್ಲ.
Then what is the second condition? Employee and other officer who are in the service of the bank on or after 1686 and has joined so and so, who has been resigned from the service of the bank and who are otherwise eligible to join that pension scheme while in the service, and who agreed to refund that bank an entire bank contribution to provident fund received by them at the time of their so and so, who agreed to execute that undertaken as per the draft provided by the bank. All such eligible former employees as mentioned above and their survivor spouse or eligible family members be entitled the pension, family pension, if they exercising that option subject to the following conditions. These options has to be exercised, you have to be entitled.
I am ready to pay the provident fund. Swami, ಅದಕ್ಕೂ ರೆಡಿ ಇದೆ. ಒಂದ್ಸತಿ
ಇವರಿಗೆ ಯಾವಾಗ ಇಷ್ಟ ಬಂದ್ರೆ
ಪರ್ಮಿಷನ್ ಕೊಟ್ಟ.
Madam, I am hearing him.
Please, I'm sorry.
ಪರ್ಮಿಷನ್ ಕೊಟ್ಟ ಅಂದ್ರೆ ಇವತ್ತು ನಾನು ರೆಡಿ ಇದ್ದೀನಿ, ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೆ.
No, this scheme has been come in the year 2022.
23.
They said that 6 months from the date of that scheme has been came.
My lord, ಅವರು ಓಪನ್ ಮಾಡಿಲ್ಲ ಸ್ಕೀಮು. ಅವ್ರು ಏನಂದ ಅಂದ್ರೆ ಸ್ಟಿಲ್ ದೇರ್.
Have you stated in that petition that they have not opened the scheme, therefore I have not opted? ಎಲ್ಲಿದೆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ? ಎಲ್ಲಿದೆ? ನೀವು ಆ ಪಿಟಿಷನ್ ಹಾಕಿದಾರ ಅವ್ರ ಕೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ. You don't know that what is that pleaded in that petition, mister? Have you stated in that petition?
ಅದು ಆಪ್ಷನ್ ಓಪನ್ ಮಾಡಿಲ್ಲ
ಅಂತ ಹೇಳಿದಿರಾ ನೀವು ಅಂತ ಪಿಟಿಷನ್ ಅಲ್ಲಿ? If you stated, then I will ask to reply.
ಬಟ್ ಆ ಎಂಡಾಸ್ಮೆಂಟ್ ನಲ್ಲಿ ಇದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳೇ ಇಲ್ಲ. ಎಂಡಾಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ರೀಸನ್ ಅಸೈನ್ ಮಾಡ್ತಿರೋದು ನಾವು ಕೊಡಕ್
You
ಬರಲ್ಲ.
forget about that. To claim that pension, there are certain conditions, whether you are satisfied or not. To entertain your claim, have you opted it or not? That is what that I want to see. See, you have relied on that condition 4. It says that these are all the following conditions. Have you opted it? If it is not opted, then you have to say they have not given options. Therefore, I have not opted. Have you pleaded in this?
ಇಲ್ಲ ಅದು ಹೇಳಿಲ್ಲ.
ನಾನೇ ಓದ್ಬೇಕಾ petition?
No, my lord, it is not.
ನಾನು ಟ್ವೀಟ್ ಮಾಡಿಲ್ಲ.
See, these are all the conditions, mister. You first satisfy that, yes, I have satisfied all these conditions. See, once you have satisfied the condition, option is not left for them. They can't say that we will deny.
But
First
that is
ನೋಡಿ.
not the reason assigned in the impugned ordinance. Impugned order ನಲ್ಲಿ ನಾವು ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. It's a cryptic.
ಆಯ್ತಪ್ಪ,
Reason
ನಾನು
assigned
ಇಷ್ಟು ಕ್ಲೀನ್ ಆಗಿ ಅರ್ಥ ಆಗಂಗೆ ಹೇಳ್ತೇನೆ. ನಾನು ಹೇಳೋದೇ ತಪ್ಪೋ ಅಥವಾ ನಿಮಗೆ ಅರ್ಥ ಆಗಲ್ವೋ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. Yes, yes.
Obliged,
Yes.
Lord. I shall produce it next.
Produce that. I think that options available for them to reject if you are not opted within the time. If you are opted, I don't think they have any options to say that we will not grant it. That may be the distinction. You verify that. Yes.
Obliged.
Yes, 2 weeks.
Cell number 47 adjourned. Cell number 48, Vinay Kirti Ampar petitioner, N. Kumaraswamy.
Appear for the petitioner.
Yes.
The petitioner challenged the endorsement, your lordship. The petitioner father was working as a Hindi teacher in aided institution. In service, he passed away on 25/12/2022. So he sought for the compassionate appointment petitioner. His appointment, he was appointed, your lordship, as per the annexure. Page 33, annexure.
Yes. On 10th February. Yes.
To annexure L, your lordship, he was appointed under the compassionate ground. The said appointment has been approved by the BEO and recommended for the approval. Your lordship, at annexure N, page 35. Along with the checklist is submitted to the same annexure N, page 35, your lordship.
ಏನಾಗಿದೆ ಈಗ?
Then after, your lordship, after submitting the checklist, all other things, they issued the endorsement stating that, your lordship, page 51, 49 and 50.
Yes.
ಚಂದನ್ BS and ಸುಧಾಕರ್ MP ಇವರು ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ page 51, annexure S, your lordship.
51 is something else.
Annexure P 49.
Annexure P na?
Typed copy, then annexure. Yes, the BEO was communicated last annexure.
ಎಲ್ಲಿದ್ದಾರೆ P? Dated?
Dated 5/4/2025.
Yes. Yes ಅಂತ ಹಾಕಿದಿರಲ್ಲ.
Yes.
Yes.
ಚಂದನ್ BS and son of ಸುಧಾಕರ್ MP ಇವರು ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ಪಟೇಲ್ TG ರಂಗೇಗೌಡ ಸ್ಮಾರಕ ಪ್ರೌಢಶಾಲೆ ಗುಡುಗೊಂಡನಹಳ್ಳಿ ತಾಲೂಕು ಈ ಶಾಲೆಯ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿರುವುದನ್ನು ಅನುಮೋದಿಸಲು ಸಲ್ಲಿಸಿದ ಪ್ರಸ್ತಾವನೆಯು ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಶಾಲಾ ಆಡಳಿತ ಮಂಡಳಿ ವಿವದ್ಯವು ಮಾನ್ಯ ಆಯುಕ್ತ ಕಚೇರಿ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಂಖ್ಯೆ ದಾಖಲಾಗಿದ್ದು ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿರುವ ಪ್ರಸ್ತಾವನೆ ಅವಕಾಶ ಇರುವುದಿಲ್ಲವೆಂದು ಹಿಂದಿರಿಸಿ.
ಏನದು ಮೇಲ್ಮನವಿ?
That is the management dispute. That is that the one of the staff members, teacher was promoted. The said promoted has been challenged before that committee is not. Now that appeal is also dismissed, your lordship, by the commissioner.
Yes, madam. Yes, what you say that? Now you have issued an endorsement saying that appeal is pending. Now that appeal is disposed of. Hmm.
They've given a reason, my lord, that there was a case pending. That's the reason they cannot consider in 14.
What case is pending?
But there is an OS
OS is between the management.
regarding the management, my lord. They should have not considered this.
ಇದರಲ್ಲಿ ಕಮಿಷನರು
ಮೇಲ್ಮನವಿ ಸಂಖ್ಯೆ ನೀವೇ ಅದು ಬೇರೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಅಲ್ಲಿರೋದು
ಅದು ಸೂಟ್ ನಂಬರ್ ಹಾಕೋದನ್ನ ಯೋಲ್ಲ ಶಿಪ ಕೈಂಡ್ಲಿ ಸಿ ಅಟ್ ಪೇಜ್ ಅನೆಕ್ಷರ್ ಕ್ಯೂ 49. OS ನಂಬರ್ ನ ಇದಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ.
ಸಂಖ್ಯೆ 112 of 2024.
ಅದು ಸೂಟ್ ಆಕ್ಚುಲಿ ಕಮಿಷನರ್ ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇರೋದು ದಿಸ್ ಒನ್ 3 ಆಫ್ ವೆರಿ ಸೇಮ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ನಾನು ಈಗ ಕೊಟ್ಟಿದ್ದು
ಇದ್ಯಾವುದು 112
ಅದು OS ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ. ಕಮಿಷನರ್ ಇದನ್ನ ನಂಬರ್ ತಪ್ಪು ಮಾಡ್ಕೊಂಡು ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಅಲ್ಲ OS ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
OS ಪೆಂಡಿಂಗ್ ಇದೆ. ದಟ್ ಈಸ್ ದ ಇನ್ ಪರ್ಸ್ಯೂಯನ್ಸ್ ಆಫ್ ದ ಅಲ್ಲ
ವೇರ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್. ಎಲ್ಲಿದೆ ಏನಿದೆ? ವಿಚ್ ಇಸ್ ದಟ್ ಇನ್ OS ನಂಬರ್?
OS number 114
112 of ನಿಮ್ಮ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದಿರ ನೋಡಿ. ಹಿಂದಿನ ಲೈನ್ ಹೋದ್ರಿ.
ಕಮಿಷನರ್ ಮುಂದೆ ಪೆಂಡಿಂಗ್.
ಶಾಲಾ ಆಡಳಿತ ವಿವಾದವು ಮಾನ್ಯ ಆಯುಕ್ತರ ಕಚೇರಿ ಬೆಂಗಳೂರು. ಇಲ್ಲಿ ಮೇಲ್ಮನವಿ 1 and 2 of 2024 ಅಂತ ಹೇಳ್ತೀರಾ. ಅದು ಸೂಟ್ ಅಂತ ಹೇಳ್ತೀರಾ. ನಿಮ್ ಮುಂದೆ ಸೂಟ್ ಬರುತ್ತಾ? ಏನ್ ಮಾಡ್ತಾರೆ ಅವರು ತಪ್ಪಾಗಿದೆ ಅಂತಂದ್ರೆ ವೈ ಎಸ್ ದೇರ್ ಮೇಡಮ್? ಹೂ ಇಸ್ ದಟ್ ಆಫೀಸರ್?
ಮೇಲ್ಮನವಿ ಪೆಂಡಿಂಗ್ ಇದ್ದಿದ್ದು ಇದೊಂದು, ಅದನ್ನ ಅದ್ರಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಹೇಳ್ತಾರೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇಸ್ ದಟ್.
What is actually mean? Whether he is referring to that suit or that appeal pending before you?
My lord, they are mentioning mail manavi, my lord, but the case number referred is pertaining to.
No, that's why I am asking that there is one appeal, mail manvi sankhya 3 of 2025 that he has produced. Yes, whether you are referring to that or you are referring to that suit.
There is an error, my lord, in the endorsement.
ಈಗ ಅವನ್ನೇ ಹೊಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕನ್ನ ಅವ್ನ ಆಫೀಸರ್ ಯಾರು ಬರ್ದಿದ್ದಾನ ಅವನ್ನ ಏನು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Yes, anyhow reconsider that now that yes. ನೀವು ಆಫೀಸರ್ಸ್ ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅಂತ ನೋಡಿ, ನಾವ್ ಇಲ್ಲಿ ಕುತ್ಕೊಂಡ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಹೌ ಸೀರಿಯಸ್. 3 ಲೈನ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಏನು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು he has not applied his mind.
Reasons are not.
Yes. In this writ petition, ಏನಿದು 11/3/2025 ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹಾಕಿದ್ದೀರಾ? ವಾಟ್ ಇಸ್ 11/3/2025 ಮಿಸ್ಟರ್?
ಅದು ಫಸ್ಟ್ ಉಪನಿರ್ದೇಶಕರು ಕೊಟ್ಟಿದ್ದನ್ನ BEO ನೆಕ್ಸ್ಟ್ ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಸೇಮ್
ಇವರು ಹಂಗೆ ಅದನ್ನ ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. He is also said that ಸಿವಿಲ್ ಜಡ್ಜ್ ನ್ಯಾಯಾಲಯ ಅಂತ ಬರ್ದಿದ್ದಾರಲ್ರಿ ಇಲ್ಲಿ. ಆಯುಕ್ತರ ಕಚೇರಿ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ ಹಾಗೂ ಮಾನ್ಯ ಸಿವಿಲ್ ಜಡ್ಜ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿರುತ್ತದೆ. What is that dispute in that?
The committee dispute, management dispute. Your Lordship, they initially preferred the writ petition before this honorable court.
ಅದಕ್ಕೂ appointment ಗೂ what is that? Yes. In this writ petition, petitioner called in question endorsement dated 11/3/2025 issued by respondent third respondent and endorsement dated 5/4/2025 issued by respondent number 4, whereby request of the petitioner appointment on compassionate ground for approval of the appointment on compassionate ground by the management. Petitioner father, late MP Sudhakar, was appointed as Hindi teacher by fifth respondent institution.
No, Your Lordship.
To that aided post on 24/11/2023. Petitioner father died on
Your
24/11/1993. Yes.
He was appointed in Vishwa Bharati High School, Markal. Then because there was no posts available in that post, I permitted me to approach the.
Yes, he was appointed as an Hindi teacher by Vishwa Bharati High School, Barakanale, Chikkanayakanahಳ್ಳಿ, Taluk, Tumkur. By appointment order dated 24/11/1993. Against that aided post. Petitioner father was died on 25/12/2022 while he was in service, leaving behind his wife, his son, the petitioner, and daughter. ಯಾವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ?
In time ಅಲ್ಲಿ ಹಾಕಿದೀವಿ, Your Lordship. 10/2/2023.
Said Sri Vishwa Bharati High School a petitioner has submitted a representation on 10/2/2022 seeking for appointment on compassionate ground. The respondent institution has passed a resolution on 22/9/2023 appoint the petitioner on compassionate appointment as a second division assistant
at fifth respondent, before the fifth. At fifth respondent institution.
Who has passed the resolution?
First resolution passed by the Vishwa Bharati Vidya Sansthe. Since there is no posts were available, so approach the fifth respondent. There one SDC posts were available. Accordingly, that aided institution.
They have passed any order?
Yes, at resolution at page 32. Then appointment order is at annexure L.
Since there was no SDA post available in Vishwa Bharati Education Institution, they have given a NOC to appoint the petitioner in fifth respondent education institution. Accordingly, by annexure L dated 19/6/2023, fifth respondent institution has appointed the petitioner as a second division clerk, and they have sent a recommendation for approval by annexure M dated 17/2/2024.
Annexure N BO recommended for the same and send the same to the.
Yes. Thereafter, respondent number 4 forwarded that recommendation with details to whom he has recommended.
ಉಪನಿರ್ದೇಶಕರು ಸಾರ್ವಜನಿಕ ಇಲಾಖೆ. In turn, he sent to the third respondent.
And he has forwarded the same to the third respondent. Thereafter, third respondent has issued an impugn endorsement by annexure or dated 11/3/2025, stating that there is a dispute pending before that dispute between the two groups are.
ಹೌದು ಅಲ್ಲ, ಮ್ಯಾನೇಜ್ಮೆಂಟ್, ಇಂಟರ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್.
Yes, there is a dispute is pending in respect of the management before the civil court as well as commissioner. The appeal is also pending before that commissioner. The similar endorsement has been issued by fourth respondent by annexure S 5/4/2025. Learned counsel appearing for the petitioner has filed a memo enclosing the order passed by the commissioner in the appeal in appeal number 3 of 2025, and also submitted that the dispute pending in that civil court in OS number 1 and 2 of 2024 is nothing to do with that. Approval of the appointment of the petitioner is concerned. The impugn order annexure R and S is issued without application of mind, and it is not in a speaking order. No proper reason has been assigned to not to consider that recommendation of the petitioner for approval. On this short ground of the writ petition has to be allowed, the impugn endorsement has to be quashed. Accordingly, impugn order so and so is quashed. Matter is remitted back to that respondent number 4 to reconsider that proposal sent by.
Third respondent is already recommended. It is third respondent.
Yes. Reconsider that matter afresh in accordance with law within 3 months from date of receipt of the copy of this order. It is made clear that this court has within 3 months from date of receipt of the copy. Yes.
Cell number 49, Vijay Kumar for petitioner.
That observation is that without taking the consideration of the pendency of the civil dispute.
No, that's what said, that they have not, see, without application, adukku idukku yen sambandha anta they have not explained in that endorsement. That's why I said, yes.
49, Vijay Kumar for petitioner, Prakash T. for
Petitioners in this matter, Lord.
Yes.
On the last occasion, your lordships has directed the government to, Lord, secure instructions with regard to what is the position in respect of the amendment to the bylaws or the C&R rules, Lord, where the filling up of the post of director cum dean in the Chamarajanagar Institute of Medical Sciences. Lord, so the petitioners, Lords, are all employees of the institution. Lord, they are all eligible to be appointed or to the post of the director cum dean.
Yes.
On the seniority basis, Lord. Lords, the government, Lords, have appointed, Lords, fourth respondent, Lord, on an in-charge basis, Lord.
Where is that order?
Annexure D, Lords. Annexure D, page 65. Lord, questioning this, Lord, the petitioners had preferred a writ petition before this honorable court, and this honorable court is pleased to dispose of the writ petition at Annexure G, page 75.
Yes.
Lords, I request my lords to kindly may be permitted to read last 5 lines of the judgment, Lords, page 81.
Yes.
If the fifth response appointment is only as an additional charge on temporary arrangement, The decision to appoint dean and director to fourth respondent on regular basis must be taken in an expedited manner, and temporary arrangement cannot continue for any unreasonable period. Lord, this order of appointment is made, Lords, in the year 2023. Lords, 26/7/2023. Till today, Lords, though we are eligible as per the bylaws, which is Lord produced at Annexure A. For a moment, Lord, page 45 may kindly be seen, Lords. Page 45.
Yes.
The prescribed qualification to hold a post of director cum dean.
45.
Yes, Lord. Item number 1, Lords.
Yes.
First, director cum dean for the new medical college. Lords, the prescribed qualification is at next column, Lord.
Yes.
Should possess a recognized postgraduate medical qualification recognized by MCI, NMC, by an recognized medical institution with a minimum of 10 years teaching experience as professor or associate, out of which 5 years as professor in autonomous government medical institution in Karnataka. All these persons, Lords, are appointed, Lords. Kindly see the statement which I have produced at
Now
page
that where is that order of appointment of the fifth respondent as temporary?
65, Lords, page 65.
ಏನಂತ ಹೇಳ್ತಾರೆ?
ಡಾಕ್ಟರ್ H.G. ಮಂಜುನಾಥ್ ಪ್ರಾಧ್ಯಾಪಕರು ಹಾಗೂ ವಿಭಾಗದ ಮುಖ್ಯಸ್ಥರು, ಅರವಳಿಕೆ ವಿಭಾಗ, ಮೈಸೂರು ವೈದ್ಯಕೀಯ ಕಾಲೇಜು ಮತ್ತು ಸಂಶೋಧನಾ ಸಂಸ್ಥೆ ಮೈಸೂರು ಇವರನ್ನು ಸಾರ್ವಜನಿಕ ಹಾಗೂ ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ತಕ್ಷಣ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಾಗೂ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಚಾಮರಾಜನಗರ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರ ಹುದ್ದೆಯ ಅಧಿಕ ಪ್ರಭಾರದಲ್ಲಿ ಇರಿಸಿ ಆದೇಶಿಸಿದೆ.
Yes, madam.
Regarding to the amendment to the cadre and recruitment. Accordingly, my lord, the cadre and recruitment draft was published. And my lord, there were certain procedures after receiving the objection. Your lordship had posted a question why there was a delay, because the order was of the
2020.
month of March 2020.
Yes.
So therefore, your lordship had asked me to secure the record. My lord, the original records, my lord, has been sent to the finance department. I have the Xerox copy.
Yes, yes. No, you tell me, even it should be from 2023 what your steps has been taken. Forget about that. 2024, this court has disposed of as expressing an opinion that it cannot be continued for long. After that, what is the steps you have taken?
And also, Lords,
have you taken that contention before this court that we require to amend that bylaws and all in earlier writ petition?
Lords, kindly see paragraph 5 may kindly be read. Lords, I may be permitted to read it. Paragraph 5 of the judgment clause.
Yes.
This stand in the court's opinion reduces the scope for this court's interference. This court concludes that the petition must be disposed of, directing the fourth respondent to finalize the amendments on the annual expeditiously and directing the first and fourth respondents
have taken that
to
content.
ensure that the
Yes,
notice
now that, tell me that from that day, what are the steps you have taken?
and also, Lord, there was a direction for them to, Lord, call for next few lines, Lord.
Yes.
First and fourth respondent to ensure that the notice inviting application to fill up the posts of dean and director with the fourth respondent is published before 30th May 2025.
Ensure that notice inviting that application to fill that post of dean 30th 5/2025.
ಒಳಗಡೆ ಅವ್ರು ಕರಿಬೇಕಾಗಿತ್ತು. ಇದುವರೆಗೂ 2 ವರ್ಷ ಆದ್ರೂ ಅವರು
Yes, madam. Why have not filed the contempt, Mr. What has happened to the
contempt is filed, Lords. Unfortunately, Lords, it is not reaching before the court all one. And my kindly see the prayer which is made in the writ petition, Lords. I may be permitted to place certain material before your lordship, Lords. What is the present situation in the institution, where, Lords, the students have gone on strike against the very dean and director, Lords. Kindly see.
Yes, madam. What have you done that?
Can I forward?
Yes. I could read. Could you?
Serious allegations are made against the director cum dean, Lords. The students are not provided with the proper food and not even, Lords, environment to study, Lords, where the students have gone on strike, which is
Yes,
enclosed along with the memo, Lords.
The table, my lord, contains along with the date, my lord, the process which has been carried out, my lord,
Yes.
for drafting the amendment of schedule and recruitment.
Yes.
Started from 3/4/2025. My lord, sign your receipt, the
ನಡೆದ ಆಡಳಿತ ಮಂಡಳಿ ಸರ್ಕಾರಿ ವೈದ್ಯಕ ಕಾಲೇಜು ಏಕರೂಪ ಉಪವಿಧಾನ ಹಾಗೂ ಹೊಸ ಸಿಆರ್ ನಿಯಮಗಳನ್ನು ಆದಷ್ಟು ಬೇಗ ರೂಪಿಸಲಾಗುವುದು ಮತ್ತು ನಿರ್ಧರಿಸಿದೆ. ಕರಡು ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮ ಪ್ರಕಟಿಸಿ ಆಕ್ಷೇಪಣೆ ಆಹ್ವಾನ ಮತ್ತು ಪರಿಶೀಲಿಸಿದ ನಂತರ ಆಡಳಿತ ಮಂಡಳಿ ಅನುಮೋದನೆ ಪಡೆದು DME ಎಲ್ಲ ಸಲ್ಲಿಸುವುದು. ಅದರಂತೆ ಜೇಮ್ಸ್ ರಾಜ್ ಸಂಸ್ಥೆ ಕರಡು C&R ಅಂತರ್ಜಾಲ ಪ್ರಕಟಿಸಿ ಆಕ್ಷೇಪಣೆ ಆಹ್ವಾನಿಸಲಾಗಿರುತ್ತದೆ. ಕರಡು ಸೀರಿಯಸ್ ಆಕ್ಷೇಪಣೆ ಕುರಿತು ಚರ್ಚಿಸಲಾಗಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧ್ಯಕ್ಷರ ಸಭೆ ನಿಗದಿಪಡಿಸಲಾಗುತ್ತೆ. ಆಕ್ಷೇಪಣೆ ಕುರಿತು ಚರ್ಚಿಸಲಾಗಿದೆ. ರಾಜ್ಯ ಏಕರೂಪ ಉಪನಿಯಮಗಳ ಹೊಸ CR ನಿಯಮಗಳು ಅಳವಡಿಸುವ ಕುರಿತು ವಿಶೇಷ ಆಡಳಿತ ಸಭೆ ನಡೆಸಲಾಗಿದೆ. C&R ಮಂಜೂರಾಗಿರುವ ಹುದ್ದೆಗಳನ್ನು ಸಂಖ್ಯೆಯನ್ನು ನಮೂದಿಸಿಕೊಂಡು ಪ್ರಸ್ತಾವಿತ ಆರ್ಥಿಕ ಇಲಾಖೆ ಅನುಮೋದನೆ ಪಡೆದು C&R ನಿಯಮಗಳನ್ನು ಅಳವಡಿಸಿಕೊಳ್ಳುವಂತೆ DME ಅವರಿಗೆ ಸರ್ಕಾರಿಗೆ ಸೂಚಿಸಲಾಯಿತು. ಮೇಲಿನಂತೆ ನಿರ್ದೇಶಕ MD ಎಲ್ಲಾ ಸುತ್ತನ್ನು ಸಂಸ್ಥೆಗೆ ಸೂಚಿಸಿ ಮತ್ತು ಚೇರ್ಮನ್ ಚಂದ್ರಶೇಖರ್ ಪ್ರಸ್ತಾವ ಮತ್ತು ಏಕ ಕಡತದ ಮೂಲಕ ವೈದ್ಯ ಶಿಕ್ಷಕರು ನಿರ್ದೇಶನಾಲಯ ಸಲ್ಲಿಸಲಾಗಿದೆ. DME ಇಂದ ಸದರಿ ಪ್ರಸ್ತಾವ ಪರಿಶೀಲಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದನ್ನು ಪರಿಶೀಲಿಸಿ ಆರ್ಥಿಕ ಇಲಾಖೆ ಅನುಮೋದನೆ ಪಡೆಯಲು ಆರ್ಥಿಕ ಇಲಾಖೆ ಕಡತವನ್ನು ಸಲ್ಲಿಸಲಾಗಿ ಆರ್ಥಿಕ ಇಲಾಖೆ ಚಾಲ್ತಿಯಲ್ಲಿರುತ್ತದೆ. Yes, after that what has happened?
Now the file is pending before the finance department.
Then we will ask that finance secretary to be present. Either you get that what finance secretary is doing or let he has to be answered.
Raise it on the next date of hearing. What is the status in the
No,
finance
you
department?
will stop that finance department. After that, nobody is doing that. Finance department is beyond everything. He is also the government. This thing he has to say when there is a court has given a specific direction. 10/12/2025 he has placed this before that finance department. What the steps has been taken when there is in a court directions? The reason is that if the contempt has been precipitated, you could have been done it. Now that
I have done it, my lords. I respectfully submit, my lords. Lord's proposal is sent by the institution on 12/5/2025.
Yes.
More than 144 times the file has been moved from one table to another table. I have the information with regard to the very same.
Yes.
The three persons, my lords, are circulating the files as and when the matter is listed before the court. That circulates for more times from the table to table.
By Tuesday, within week, whether you are going to the finance department will give a concurrence or not. Otherwise, you will ask that additional advocate general to appear before this court. We will ask that.
For a moment, lords, the memo along with document which I have placed. For a moment, Mr.
No,
kindly, I request, my lord.
Unless bylaws
I bow down to your lordships understand.
Bylaws is amended, there cannot be any appointment. We can't direct you to appoint because bylaws.
Please, lord, please.
Now
Lord.
that
I want to bring it to your
precipitating that to.
Yes,
bylaw has to be amended. Yes.
Please, lord, I want to bring it to your lordship's knowledge how the dean and director is presently executing his powers, lords, and on the basis of.
But we can't do
for
anything.
A moment, lord, I bow down to your lordships as well.
I understood that, Mr.
Lords, kindly,
What
students have written a complaint against lords, the very dean and director to them, all the authorities.
I am not dealing with any public interest litigation.
No,
so
lord.
I can't do anything.
The students, lords, who have raised a complaint, they are not providing with the proper food also, lord. That is what I wanted to bring it to your lordship.
Is why we asked that maybe to retain that fifth respondent there.
Students have went on a strike, lords, against the very dean and director where there is a threat for the students, lords. They have threatened the students that you will be.
You ascertain if you get any instruction that finance department is required more than 1 week, you ask that additional advocate general to appear on Tuesday.
Let the director not function the statutory powers, lords, till such time, lord.
No. Who will be administrator, Mr.? That cannot be.
Lords,
That's one request, my
No,
lord.
he is there from last how many 2 years? You are not challenged that. Yes.
Lord, we have challenged, lord. That is the writ petition which is disposed before filed before this honorable court.
Yes.
In 23 itself, we have questioned, lord.
I appear for respondent number 3.
Who is
My
respondent?
senior name is showing on behalf of respondent number 3, my lords. Because my senior appeared in the earlier writ petition on behalf of SIMS Institute, my senior was directed to accept the notice, my lord. But we are not the panel and there is no instructions
What
from
the
the SIMS.
problem in all cases, Mr.
Lord, the earlier lordships, lords, kindly see the order.
Where is that order? When the order is passed?
Page 75, lords, Annexure G, where
Wait, Mr.
third respondent was represented by Mr. Prakash T. Hebbar, lord. That's therefore, lord, the order is passed to.
ಆಯ್ತ್ರಿ ಅವ್ರು ಯಾವಾಗ ಬೇಕು ಅವಾಗ ಚೇಂಜ್ ಮಾಡ್ತಾ ಇರ್ತಾರ್ರಿ.
The panel ಆಗಿಲ್ಲ. ಅದು
ನೀವು ಇಲ್ಲ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೋಬೇಕು.
ಆಯ್ತು, ನಾನು ತಗೊಂಡ್ರೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂತೀನಿ. By next day.
ಪ್ರೋಸೆಸ್ ಕಟ್ಟೋದು ಕಷ್ಟ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯಾರೋ ಒಂದು ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಹೇಳ್ಬಿಡ್ತಾರೆ.
ಇಲ್ಲ, it is order is passed, lord, because they have already represented in the earlier proceedings, lord.
Yes. Now he is not there. What you say?
I will take a hand summons in respect of third respondent.
Office is directed to delete the name of P. Prakash T. Hebbar for respondent number 2 and 3. Learned counsel for the petitioner is directed to issue emergent notice to 2 and 3. In addition, petitioner is permitted to take out hand summons to respondent number 2 and 3 at the request of government advocate. Leads this matter on 20th. Yes.
My lord, can it be
Grateful.
on 22nd?
No, 22nd. After that, your appearance of your advocate general will see. Yes, you told this. One day time has been given in between. You asked them.
22nd, my lord. Additional application will be appearing another matter in case if something happens.
Yes, 22nd. Yes. 22nd. Grateful.
Obliged.
Cell number 50 adjourned. Cell number 51 Padmanabha R for petitioner, government advocate.
For petitioner, my lord.
Yes.
My lord, this matter being heard, pensionary benefit, pension not settled, my lord. Proposal has been sent. Next year.
Directing the respondent to settle the pensionary benefit and pay the monthly pension. Where you are working, Mr.
My lord, at respondent number 5, my lord. And after my at the time of retirement, my lord, pension the proposal has been sent.
Where is that?
Word annexure F, my lord.
When did
Page
you retire?
26.
20?
Page 26.
Yes.
My appointment has been approved with granting aid, my lord. Page 24, annexure E.
ಅವನಿಗೆ ಸಲ್ಲಿಸಿದೆ. Yes, it is sent to that director. ಆಮೇಲೆ ಏನಾಯ್ತು?
Thereafter, my lord, annexure H and K, my lord. They have given endorsement, my lord. Page 31, my lord. Neither the institutional grant copy nor the salary grant copy are pasted in SR or enclosed to pension papers, my lord. My lord, while sending the pension proposal, my lord, all the papers has been sent. Attached to the proposal, my lord.
With about complying with that request submitted duly complied with so and so. Please note that treat this close so and so. Account officer ಇದ್ಯಾರನ್ನ ಕಳ್ಸಿಕೊಟ್ಟಿದ್ದಾರೆ annexure ಹೆಚ್ಚು management ಗೆ.
Last is the hearing. What she was referring to, a lecture. There is a recommendation, my lord, of the department.
Where is that?
Lecture J, my lord.
Yes.
To the.
In spite of this, my lord, the respondent number 4, my lord. The notice has to be issued, Mr. Ambarish, my lord, to represented in other matter.
Serial number ಎಷ್ಟಿದೆ?
Sir, 51, sir.
51.
ಎಲ್ಲ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ರಲ್ಲ ನೋಟಿಸ್. Yes. What is his name? Amresh?
N. Amresh, senior CGSC.
Yes. N. Amresh is directed to. Take notice for respondent number 4. Counsel for the petitioner is directed to serve one set of copies. Office is directed to show his name. Leave this matter next week. You copy ಕೊಡಿ ಅವರಿಗೆ ಅವರು appear ಆಗ್ತಾರೆ ಅಂತ accountant.
Date may be fixed.
Yes, leave this matter on 5th.
Cell number 52 Balraj AC for petitioner, MR Sinchana.
Yes. Yes, Mr.
I need to file my objections, my lords, next week, any date.
What is that relief you are
Sir, madam is to consider my representation for promotion. Promotion, my lord, from the office superintendent to registrar. And the executive engineer duly recommended my claim, my lord. After annexure G.
Consider that.
My lords, what happened? I have already sent a draft copy, my lords, only one date, my lords.
Yes, let her file. By filing an objection.
Tuesday, my lords,
Yes.
I'll file.
Leave this matter on 22nd.
Obliged, my lords.
Cell number 53 adjourned. Cell number 54 Siddhanur Vishwanatha for petitioner, N. Naresh.
Yes. Siddhanur.
I am for the. Here, my lord, the petitioner is working as a assistant manager in a respondent institution. My lord, he is eligible for the post for manager. Name of the in eligible promotion list, it is omission by the annexure
J, annexure N of the promotion list, my lord. My lord, in earlier, my lord, the DPC committee has recommended the name of the eligible candidate list in the annexure J dated 13/5/2025. In that eligible list, my lord, appears the name of the petitioner in serial number 9, serial number 5, my lord. My lord, has tenure of 23/11/2009 to 22/11/2024, 5 years completion of as a assistant manager, my lord. My lord, criteria of the my lord, it's very clear that my lord may kindly go through that annexure J of the my writ petition, my lord, that is 13/5/2025, page number 30, my lord. In serial number 5, my lord, the Muralidhar M, the name of the petitioner name mentioned that in dated DPC recommendation of eligible candidate for the eligible candidate for the promotion for manager post, my lord. Even though, my lord, as per annexure K, I submitted representation also for consider for promotion for in seniority list.
From
in
which
seniority,
post to which post?
Assistant manager to manager, my lord.
Yes.
My lord, even though, my lord, in finally annexure N, which is published by the respondent in page number 35, my lord, my name is omitted in that promotion list, my lord. There is no reasons, there is no any clarification related to this promotion list, my lord. My lord, as per annexure.
Yes, Mr. Harish, what is?
The promotion is not automatic. Kindly see page number 38.
Yes.
The rules. It starts with post-wise rules.
Yes.
For according promotion to employees.
Yes.
Now kindly come to page number 53, which is the relevant portion towards promotion to the post of manager.
Yes.
The BMRCL Employees Cadre and Recruitment Rules 2014 provides for promotion to employees working in the cadre of assistant manager, technical and assistant manager general to the post of manager if the employee has put in at least 5 years of service as assistant manager and, this is important,
yes,
secured satisfactory performance assessment in the last 3 years.
Yes.
The service counts from the date of reporting to the post of assistant manager in BMRCL. The last 3 years performance assessment means the performance appraisal reports in respect of the employee for 3 preceding years to the year of promotion.
Yes.
Then in number 2, selection criteria for promotion is merit in the written examination conducted for the purpose. So basically there are 3 steps. One is that he should have completed 5 years in the cadre of assistant manager, which he has. Then he has to attend an examination. On the last occasion, instead of a written examination, they conducted an oral examination. He has passed even in that. But when they looked into the annual performance appraisal reports for the last 3 years, they found that in 2 years,
He is not satisfied.
it is not satisfactory. That is the reason he has not been promoted. Therefore, it is not a case of where it has been excluded by omission or anything, but he has been denied promotion.
His seniority come merit. He has to be
Yes.
in.
Yes, seniority come merit, and also his performance has to be satisfactory.
Yes, Mr.
Yes, Millard.
I will also produce the relevant records.
Yes.
In fact, in my objection statement, I had said that I will produce it in a sealed cover, but I thought it would not be proper. Is it in a written statement or subsequently? Subsequently. These are some documents. These are the minutes of
that ACR report is communicated to him.
No, I'm
No.
just.
Every year performance of the appraisal report has to be.
No, Millard. Still, I have produced Millard. May kindly go through that, Millard. I request the letter to submit it to the respondent, Millard. As per annexure M, I filed that dated 11/7/2025, page number 33, Millard. Yeah, I am seeking the detailed APR copies for kind reference. My for my promotion is due. Still, my lord, they have not.
All the 5 years
But
APS
now that-
now I have produced along with the
They
memo.
have not communicated, my lord.
No, that whatever that remedy available, will do it. But now that as per this, your performance is
My
not
lord.
satisfactory, therefore it is not
My
considered.
lord, first of all, my lord, may I kindly go through that.
I
as
can't
per-
direct them to promote you even though you are not satisfied.
My lord, first of all, my lord, may I kindly go through that page number 38, my lord, that rule, my lord. My lord, that rule, what they have read, my lord, page number 38. Selection criteria for promotion is merit in written examination conducted for the purpose. My lord,
Page?
that page number 38, my lord. Again, our
53 now.
ಅಲ್ಲ annexure P, my lord. Annexure P.
No, you come to that
ಅಲ್ಲ
promotion to the post of the manager. Don't read other portions.
ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. Bangalore Metro Rail Corporation post wise according to promotion to employees in the operation maintenance wing. ಅದ್ರಲ್ಲಿ first promotion to the yes page
Junior
number
engineer
yes, sorry
53 ಬನ್ನಿ.
53 yes
Promotion to the
please,
post
yes.
of the manager.
Yes, my lord. Promotion to the post of manager. My lord, in that, my lord, last 3 years performance assessment means performance appraisal report in respect of the employee for 3 years preceding year of the promotion. And next, my lord, selection criteria for promotion is merit in written examination conducted for the purpose. My lord, here, my lord, ಇಲ್ಲಿ ಏನು 15 ಜನ ಎಲಿಜಿಬಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಗೆ ಯಾವುದೇ ರೀತಿಯಲ್ಲಿ ರಿಟರ್ನ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕಂಡಕ್ಟ್ ಮಾಡಿಲ್ಲ.
No, that is what that this year they are not.
ಅಲ್ಲ ಎಕ್ಸಾಮಿನೇಷನ್ ಕಂಡಕ್ಟ್ ಮಾಡಿಲ್ಲ.
ನಿಮಗೂ ಇಂಟರ್ವ್ಯೂ ಮಾಡಿದ್ದಾರೆ, ನೀವು ಪಾಸ್ ಆಗಿದ್ದೀರಾ. Yes,
Question
not
of
said that.
if
Now that this performance report is concerned, you have not satisfactory. Yes.
Performance, my lord, may kindly go through that, my lord, as per their written statement, as per written statement mentioned in that page number 7, paragraph number 17 of the written statement objection filed by the respondent, my lord. Paragraph 17, my lord, page number 10.
Page number 10, paragraph
17, my lord.
Page 17.
Page
17
page 10, paragraph 17, my lord. Page 10.
Statement of objections filed
Statement
by
of objection, my lord.
EMS.
No, you have filed earlier.
Yes.
Earlier,
Yes, yes,
Not this.
yes,
My lord, in paragraph 17,
yes.
upon going through the performance appraisal report in respect of the petitioner, the DPC found that his performance in the interview and his annual performance appraisal report for the year 2002-23 continue adverse remark, and his performance in appraisal report for the year 24-25 average. My lord, here they are mentioned it is average. Whether that average is satisfactory, whether it is average is not satisfactory. What criteria they have considered for average is not as satisfactory. So that's my point of argument here, that, my lord, they have not conducted the examination. As per rule, written examination is the criteria for considering the promotion.
Yes.
Now, last 3 years appraisal, their 3 years appraisal in their observation, it is average. Average means, is it a satisfactory result or it is a unsatisfactory? The criteria for 3 years, is there any charges against me? Is there any criminal case against me? No. Is there any disciplinary inquiry against me? No. Then in what reason they have decided that I am unsatisfactory? Now the related question, adverse remark, there is nothing is adverse remark. Only the criteria, it is average. Average means what? Average means, is it the
Average.
Average means it is not unsatisfactory. Not it is average means it is satisfactory. Now, in what criteria they have decided that I am not considered for promotion?
Yes.
So, as per in the promotion, in that, my lord, annexure Q, my lord, in the same written objection, my lord, in the same written objection, my lord, in paragraph 19,
Yes.
in observation, my lord, treating the 5-year annual performance report pertaining to the petitioner and also assessment of petitioner
Paragraph?
by the same next paragraph,
Yes.
19, my lord, page number 11. Treating the 5 years annual performance report pertaining to the petitioner and also assessment of the petitioner by DPC as a confidential, respondent will submit the above record in sealed cover to this honorable court at the time of hearing. What is the seal covered proceedings, my lord? Related to seal covered proceedings, I have Produce
not
the-
sealed cover proceedings. It is not that he
What,
said. It will
yes,
be
that
produced
reason,
under-
that reason, my lord, I've produced the citation of Honorable Supreme Court, my lord, in same along with the petition, my lord. My lord,
ಅದನ್ನೇ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದು. I had taken a contention that I'll produce it in sealed cover. Then I thought it may not be proper, and therefore I have filed those documents along with a memo.
Against me, there is no criminal case. Against me, there is no.
See, sealed cover proceedings is different.
Right, my lord.
If there is any departmental inquiry, your name will be kept in the sealed cover. It is a different. He said that these documents has to be give it in that sealed cover. That's what that. It is not in a sealed cover proceedings.
Documents I had intended to produce by way of a sealed cover. Those were my instructions, but then I thought it would not be fair on the petitioner.
See, it is
Therefore,
not
I
in a
thought it
sealed
is-
cover proceeding.
Right, my lord.
Yes.
Yeah, as per their written objection, observations, I explained here, my lord. My lord, moreover, my lord, there is no remarks against me. There is no criminal case. There is no complaint. There is no inquiry against me, my lord. Then in appraisal,
this is performance your duty.
Yes, performance, my lord. It is average.
Also one of the
Average
criteria
means,
for
my lord,
consideration of promotion.
My lord.
If other candidates or performance is good and very good, then your
My lord,
case cannot
it is
be
my
considered.
lord, it is that, my lord, observation that it is average. Average is, it is a satisfactory.
Yes.
Average is not a unsatisfactory.
Yes.
So why the reason it's not in properly communicated me?
Yes.
Still, my lord, the promotion as per any filing, any observation related to promotion and related to in the statement of objection, nothing else, my lord.
Yes.
My lord, as per my lord, I am eligible for the Annexure J. Annexure J. You may kindly go through that in page number 30, my lord. I am eligible for the promotion.
Even in Annexure
That
J, I'll
DPC,
just point out
DPC is
to one.
recommended, my lord. As per Annexure DPC, it is recommended in serial number 5, Muralidhar M. My name is reflected, my lord. As on date of I am eligible, then in promotion list, my name is omitted. In what is the criteria they have considered? No, there is still, my lord, they have not replied.
Yes.
My lord, yeah. May I kindly go through
They
that?
will give a reply. You give that reply to that.
I'll just answer to the points raised by my learned friend. In Annexure J, it clearly says, this is page number 30.
Yes.
This is dated 13th May 2025.
Yes.
The last paragraph before the tabular column.
Yes.
The interview is for those assistant managers who have completed 5 years of service as on 30th June 2025. Accordingly, the list of eligible candidates who are in the zone of consideration is as under. It doesn't mean that they are eligible for promotion.
Yes.
It's only within the zone of consideration.
Yes.
Then under the rules, as this honorable court noticed, there are 3 criteria. One is...
No, is it the report of the DPC?
No, the report of the DPC is what I have produced along with the memo.
This is not, this is a list which has been prepared.
This was the list which was prepared.
This is not in a DPC. Annexure J is not
before
in a
the
DPC.
interview. Kindly see the previous paragraph.
Yes.
It says the interview for promotion from AM to manager shall be conducted on such and such date. Therefore, this was even prior to the consideration by the DPC.
Not in a DPC.
This is not the DPC report. The DPC report I have produced.
Question of interview, my lord, doesn't arise. Here only the written examination, only the criteria to consider, my lord. As for, my lord, promotion to the post
He has
of
appeared for written examination.
nothing, my lord.
No,
Yargu madayilla
there was no
examination.
written examination.
The interview he has
The
appeared.
interview he has.
Then why you have appeared?
My lord, there is no examination conducted, my
No,
lord.
therefore you have appeared in an interview, you are accepted.
Yes, my lord, I am appeared.
You can't come and say that they have to be conducted in examination when you are unsuccessful.
Not like that, my lord. Still, my lord, as per rule they have violated.
Yes.
Moreover, my lord, criteria related to appointment of the post of the manager,
Yes.
they have violated the rules and regulation of the BMRCL recruitment and promotion rule, my lord. So
Yes.
in that rule, my lord, may kindly
Power for you to exempt for examination and conducting that.
No, I cannot point out to any such rule. However, a decision has been taken by the management, and then the same has been applied to everybody.
No, that
The same criterion is applied to all the 15.
No, can it be done it to the contrary to that rules? They cannot go beyond the truths. Is there any such a power under that C&R rules that management or the board can take a decision, corporation?
I haven't examined that aspect of the matter.
Yes. That you examine.
Very
whether board has such a power to make such an exemption.
My lord, in the same page number, may kindly go through that, my lord, page 53.
Yes.
Promotion given effect to the employee based on grading the obtaining the written test in 6, my lord. And later, my lord, the marks obtained in the written test shall be valid only for promotion effected during the calendar year.
Let him answer that question. You just get that instruction.
I'll
Where is that power for you to exempt?
Very well.
Yes,
please.
When will you get back?
27th or 28th, if it is.
Yes, 27th.
27th.
Yes, read this matter on 27th.
27th, that holiday, I think.
27th holiday, namigilla. Yes. Nimigidya?
ಅಲ್ಲೇನೋ RH ಏನೋ
You want 28th? Yes, 28th.
28th.
Yes, 28th.
Number 55, Akshay Ramachandra Uddar for petitioner, A.V. Gangadharappa.
Yes.
My lords, for the petitioner, my lords, petitioner, my lords, has come before this honorable court, my lords, seeking, my lords, 30 lakh ex gratia compensation, my lords, where COVID-19 deceased, government had passed a notification, my lords, which is at, my lords, page number 12.
Yes.
I am the wife of the deceased, my lords, who is petitioner.
Yes.
I have filed my representation, my lords, via annexure C.
Yes.
At page number 15, my lords. Now that, my lords, the respondent number 3 has come before this honorable court, my lords, and filed objection, stating that, my lords, the daughter of the deceased, my lords, has filed objections. My lords,
Now,
whereas,
where is
my
that
lords,
government order that you are entitled for compensation?
annexure B, my lords, page number 12.
Well, where is that? What is that order says?
Order says, my lords, Shri Narasimurthy, my lords, got it, my lords?
Yes, yes.
ದಸರ್ ಅವರು ಕೋವಿಡ್-19 ಸೋಂಕಿನಿಂದ ಮರಣ ಹೊಂದಿದ್ದು, ಸದರಿ ನೌಕರರ ಅವಲಂಬಿತರಿಗೆ ಪರಿಹಾರವನ್ನು ಮಂಜೂರು ಮಾಡುವ ಕುರಿತು ಉಲ್ಲೇಖ 2ರ ಆರ್ಥಿಕ ಇಲಾಖೆಯ ಆದೇಶದಂತೆ ಕ್ರಮ ವಹಿಸಲು ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. ಉಲ್ಲೇಖ 2ರ ಆದೇಶದಲ್ಲಿ ಕೋವಿಡ್ ಸೋಂಕಿನಿಂದ ಮರಣ ಹೊಂದಿದ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಪರಿಹಾರ ಧನವನ್ನು ಮಂಜೂರು ಮಾಡಿರುವಂತೆ ರಾಜ್ಯದ ಎಲ್ಲಾ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳು ನೌಕರರಿಗೂ ಸಹ ರೂಪಾಯಿ 30 ಲಕ್ಷ ಪರಿಹಾರ ವಿಸ್ತರಿಸಿ ಸರ್ಕಾರದಿಂದ ಆದೇಶ ಹೊರಡಿಸಲು ಉಲ್ಲೇಖ 3ರಂತೆ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲಾಗಿ, ಉಲ್ಲೇಖ 4ರ ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ಕೋವಿಡ್ ನಿಂದ ಮೃತಪಟ್ಟಿರುವ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳ ನೌಕರರಿಗೆ ಪರಿಹಾರ ಧನವನ್ನು ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳ ಅನುದಾನದಲ್ಲಿ ಭರಿಸಲು ಅನುಮತಿ ನೀಡಲಾಗಿದೆ. ಕೋವಿಡ್-19 ಸೋಂಕಿನಿಂದ ಮರಣ ಹೊಂದಿದ ಶ್ರೀ ನರಸಿಂಹಮೂರ್ತಿ ದಿದಸರ್ ಅವರ ಕುಟುಂಬಕ್ಕೆ ಪರಿಹಾರ ಧನ ನೀಡುವ ಕುರಿತು ಉಲ್ಲೇಖಿತ ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ನಿರ್ದೇಶಿಸಿರುವಂತೆ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ವಹಿಸಲು ಕೋರಿದೆ. This is not disputed by respondent number 3, my lords. What respondent number 3, my lords, says in their objection is that, my lords, the parties, my lords, we remained absent and there is no intentional delay. And the 4th respondent, my lords, who is the daughter of the deceased, Narasimurthy's daughter, my lords, has filed objections.
What objections?
Objections, my lords, they have placed, my lords, at page number.
No, who is the petitioner?
Petitioner is the wife, my lords.
Second wife.
Second wife, but first wife is
Fourth
deceased.
respondent is the daughter through first wife.
No.
After the death of first wife, my lord, the petitioner.
Then legally wedded wife.
Legally wedded
Both
wife.
the petitioner and R4 are the class 1 heirs.
Both are legally.
Yes.
My lords, they had also filed, my lords, P&AC before the honorable district court, where, my lords, legal heirs are confirmed. These two are legal heirs, my lords. My lords, kindly, my lords, turn.
Both are entitled.
Both are entitled. Anotanta Swami, page number 22 may kindly be seen, my lords.
22.
22. Declaration, my lords, filed by the daughter, my lords, who is respondent number 4 before your lordship. ಶಿವಮೊಗ್ಗ ನಗರದ ಟ್ರಂಕ್ ಮೊಹಲ್ಲ 6ನೇ so and so ವಾಸವಾಗಿರುವ ವಿದ್ಯಾಶ್ರೀ so and so ಅದ ನಾನು ಈ ಮೂಲಕ ಪ್ರಮಾಣೀಕರಿಸುವುದೇನೆಂದರೆ, ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು, ನನ್ನ ತಂದೆಯವರಾದ ನರಸಿಂಹಮೂರ್ತಿ ರವರು ಶಿವಮೊಗ್ಗ ಮಹಾನಗರ ಪಾಲಿಕೆಯಲ್ಲಿ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದರು. ಸದರಿಯವರು ದಿನಾಂಕ so and so ರಂದು ಕೊರೋನಾದಿಂದ ಮೃತರಾಗಿರುತ್ತಾರೆ. ನಮ್ಮ ತಂದೆಯರವರು ನಮ್ಮ ತಾಯಿಯಾದ ನಾಗರತ್ನರವರನ್ನು ವಿವಾಹವಾಗಿದ್ದು, ವಿದ್ಯಾಶ್ರೀಯಾದ ನಾನು ಅವರ ಒಬ್ಬಳೆ ಮಗಳಾಗಿರುತ್ತೇನೆ. ಅವರ ಮರಣ ನಂತರ ನನ್ನ ತಂದೆಯವರು ವಿಜಯಲಕ್ಷ್ಮಿ ಎಂಬುವರ ಜೊತೆ ವಿವಾಹವಾಗಿರುತ್ತಾರೆ. ನನ್ನ ಮಲತಾಯಿಯವರಾದ ವಿಜಯಲಕ್ಷ್ಮಿ ಅವರಿಗೆ ನಮ್ಮ ತಂದೆಯವರ ಮರಣಾನಂತರ ಸರ್ಕಾರಿ ಸೌಲಭ್ಯವನ್ನು ನೀಡಲು ನನ್ನ ಸಂಪೂರ್ಣ ಒಪ್ಪಿಗೆ ಇರುತ್ತದೆ ಎಂದು ಪ್ರಮಾಣೀಕರಿಸುತ್ತೇನೆ. ವಿದ್ಯಾಶ್ರೀ ಎಸ್ ಆದ ನಾನು ನಮ್ಮ ತಂದೆಯವರ ಅನುಕಂಪದ ನೌಕರಿಯನ್ನು ಪಡೆಯಲು ನಾನು ಬದ್ಧಳಿರುತ್ತೇನೆ. So she has got that job.
They're understanding that she will get an compassionate upon. And
compassionate.
all benefit has to be go to that. Now
Only
that,
insofar as
what is
Manad,
that objection?
30 lakhs service benefits. This affidavit was filed in the year 2022. That the date is mentioned in page number 23. That subsequently, my lord, there is a dispute between the petitioner on the one hand and the fourth respondent relating to the disbursement of the amount regarding the COVID compensation amount. My lord.
L dispute ಇದೆ.
My lord, the annexure R1. She has given a objection to the corporation with regard to the dispersal of the amount. May I read, my lord?
R1.
Page 4. Typed copy is at page 6.
Yes.
ವಿಷಯ ತಕರಾರು ಅರ್ಜಿ ಉಲ್ಲೇಖ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀಮತಿ ವಿದ್ಯಾಶ್ರೀ ಬಿನ್ ಲೇಟ್ ನರಸಿಂಹಮೂರ್ತಿ ನಾನು ಒಬ್ಬಳೇ ಮಗಳಾಗಿದ್ದು ನನ್ನ ತಾಯಿಯವರಾದ ನಾಗರತ್ನರವರು ಸಹ ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ನಂತರದಲ್ಲಿ ನನ್ನ ತಂದೆಯವರು ಎರಡನೇ ಮದುವೆಯಾಗಿದ್ದು ವಿಜಯಲಕ್ಷ್ಮಿ ಅನ್ನುವರು ಎರಡನೇ ಪತ್ನಿಯಾಗಿರುತ್ತಾರೆ. ಆದರೆ ಎಂದಿಗೂ ವಿಜಯಲಕ್ಷ್ಮಿಯವರು ತಂದೆಯ ಮತ್ತು ಹೆಂಡತಿಯ ಜವಾಬ್ದಾರಿಯನ್ನು ತೆಗೆದುಕೊಳ್ಳದೆ ಸದಾ ಅವರ ತವರು ಮನೆಯಲ್ಲೇ ಇರುತ್ತಿದ್ದರು. ನನ್ನ ತಂದೆಯ ಸಾವಿನ 2 ವರ್ಷ ಮೊದಲಿನಿಂದಲೂ ಸಹ ಅವರು ನನ್ನ ತಂದೆಯೊಟ್ಟಿಗೆ ಇರದೆ ನನ್ನ ತಂದೆಗೆ COVID-19 ಪಾಸಿಟಿವ್ ಇರುವುದನ್ನು ಕರೆ ಮಾಡಿ ತಿಳಿಸಿದಾಗಲೂ ಬಾರದೆ ತಂದೆಯ ಸಾವಿಗೂ ಬಂದಿರುವುದಿಲ್ಲ. ಆಗಿನ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಮನೆಯ ಒಬ್ಬಳೆ ಮಗಳಾದ ನಾನು ನನ್ನ ತಂದೆಯ ಅಣ್ಣ ತಮ್ಮ ಸಹಾಯದಿಂದ ಸಾಲ ಮಾಡಿಕೊಂಡು ತಂದೆಯವರ ಆಸ್ಪತ್ರೆ ಖರ್ಚು ವೆಚ್ಚಗಳನ್ನು ನೋಡಿಕೊಂಡಿರುತ್ತೇನೆ. ನನ್ನ ತಂದೆಯವರ ಮರಣ ನಂತರ ಅವರಿಗೆ ಸಿಗುವಂತಹ ಸರ್ಕಾರಿ ಆರ್ಥಿಕ ಸೌಲಭ್ಯಗಳನ್ನು ಮೋಸದಿಂದ ಶ್ರೀಮತಿ ವಿಜಯಲಕ್ಷ್ಮಿರವರೇ ತೆಗೆದುಕೊಂಡಿದ್ದು ಮೃತರ ಮರಣ ನಂತರ ಎಲ್ಲಾ ಹಣ ಮತ್ತು ಪೆನ್ಷನ್ ಎರಡೂ ಅವರಿಗೆ ದೊರಕಿರುತ್ತದೆ. ತಂದೆಯವರ ಆಸ್ಪತ್ರೆಯ ಖರ್ಚು ವೆಚ್ಚಗಳನ್ನು ಮಗಳಾದ ನಾನು ನೋಡಿಕೊಂಡಿದ್ದು ಈಗಿನ ನನ್ನ ಮನೆಯ ಪರಿಸ್ಥಿತಿ ಕಷ್ಟವಾಗಿದೆ. ನನ್ನ ತಂದೆ ತಾಯಿಯನ್ನು ಕಳೆದುಕೊಂಡಿದ್ದು ಗಂಡು ಮಗುವನ್ನು ಒಬ್ಬಳೇ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ಈಗಾಗಲೇ ಅವರಿಗೆ ಸೇರಬೇಕಾದ ಹಣ ಎಲ್ಲವೂ ಅವರಿಗೆ ದೊರಕಿದ್ದು ಈಗ COVID-19 ಪರಿಹಾರ ಧನಕ್ಕೋಸ್ಕರ ಮೂರನೇ ವ್ಯಕ್ತಿಗಳಿಂದ ಸಂಘ ಸಂಸ್ಥೆಗಳಿಂದ ನನಗೂ ನನ್ನ ಕುಟುಂಬದವರಿಗೂ ತೊಂದರೆ ಮಾಡುತ್ತಿದ್ದು ಅಲ್ಲದೆ ಶ್ರೀಮತಿ ವಿಜಯಲಕ್ಷ್ಮಿಯರಾಗಲಿ ಅವರ ಕುಟುಂಬದವರಾಗಲಿ ನನ್ನ ತಂದೆಯ ಕಷ್ಟ ಸಮಯದಲ್ಲಿ ಬಾರದೇ ಇರುವುದರಿಂದ ಹಾಗೂ ನನ್ನ ತಂದೆಯ COVID-19 ಪಾಸಿಟಿವ್ ಬಂದಂತ ಸಮಯದಲ್ಲಿ ಅವರು ಯಾರು ಜೊತೆಯಲ್ಲಿ ಇಲ್ಲದೆ ಈಗ ದುಡ್ಡಿಗೋಸ್ಕರ ಬಂದಿರುವುದು ಎಷ್ಟು ಸರಿ. ದಯಮಾಡಿ ಯಾವುದೇ ರೀತಿಯ ಪರಿಹಾರ ಧನವನ್ನು ಮಂಜೂರು ಮಾಡದಾಗಿ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸುತ್ತೇನೆ. This is the objection. My lord, thereafter, my lord,
Not made be
the joint meeting was,
She's been served.
Who is appearing for her?
No one is appearing. Last time.
the joint meeting was held. When, my lord, on some occasions, my lord, the petitioners and the respondents were present. But thereafter, my lord, both of them remained absent. But in view of this position, my lord, the corporation is unable to take a decision, my lord, as to whom the
She has not appeared.
my lord, notice was served.
No, whether she has appeared. She just give a
She
complaint.
also appeared before the joint meeting.
He has appeared.
Please.
Now then.
Para
what is
3
that?
I have stated.
What
Several
they-
joint meetings were held and both parties did not agree for amicable settlement. Subsequently, the parties remained absent in the meeting.
All other retirement benefit has taken by the petitioner.
It has been taken by the petitioner.
ಆಯ್ತ್ರಿ ಇದರಲ್ಲಿ 50-50 ಮಾಡ್ಕೊಳ್ರಿ.
My lords, at page number 39, order of the Honorable District Court, Honorable Civil Court, my lords, wherein, my lords, she had filed probate and succession.
That is in respect of a amount
Other
in a,
properties,
in a
agli.
bank account,
Agli.
not in respect of the other.
There, it was rejected and she has not challenged it.
ಅದು ಬಿಟ್ಬಿಡಿ. ನಿಮಗೆ ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದ್ರೆ ನಿಮಗೆ ಬಂತು ಆಯ್ತು. ಇದು
COVID-19.
It is not on basis of that any rule. It is the government order. ಮರಣ ಹೊಂದಿದ ಸದರಿ ನೌಕರರ ಅವಲಂಬಿತರಿಗೆ ಪರಿಹಾರ. It will comes to, you can't say that on the basis of the service rules and all. Both are entitled that. Make it, give it 50% to her, you take 50%.
Correct. ಅದಕ್ಕೆ ಸ್ವಾಮಿ ನಾನೇನ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ, I gave my husband's job to her.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರ ಜಾಬ್?
ಹೌದು, ಜಾಬ್ ಕೊಟ್ಟಿದ್ದಾರೆ. She is working as
has been appointed.
She has been appointed as compassionate ground, but with respect to the disbursement of the compensation amount under COVID-19, there is an objection.
No, then she can get an appointment only after she petitioner given no objection. After taking appointment,
that is by virtue of the
page number 19, my lords.
That was in the year 2022. My lord, thereafter, later on, my lord, T&SC was filed by the fourth respondent herein, seeking for the payment of the bank amount which was kept in the bank in the name of Narsimurthy. That petition was dismissed on the ground that, my lord, even before the petition was filed, the petitioner has
you see that even after service of notice, he is not interested. She is working in your office.
I'll have to,
She's
sir,
working
if
her-
she is not represented by the council, we'll dispose of. She is not interested.
I'll get the instruction with
Yes,
regard to
through-
whether she is still working in the
No,
corporation.
compassionate appointment, it has. been
Compassionate
given.
appointment.
ನೋಡ್ತೀನಿ ಅದನ್ನ.
Let her give back that compassionate appointment, share in that all. Yes. Otherwise, she will not get, mister. First preference will goes to that wife. If wife given a consent, then children's will get.
Brother, that all those stages,
After
all
taking
those
that-
stages are over.
After taking that, she can't just.
Blood,
See that no
the
objection.
petitioner has also taken the
At
service
page-
benefits of the
At
Narsimurti.
page number 25, Manoj.
He has taken the entire amount.
She is entitled. Service benefit, she is entitled. Compassionate appointment, she is entitled.
He's
Rule says-
entitled. I have produced it, Manoj.
Brother,
Like that.
Manoj, I have produced that page number 20.
If she is a legally wedded wife, she is a wife of that deceased employee.
that
she is
so also, my lord, so also the fourth respondent is the daughter of the
Adike,
Narsimurti.
daughter,
Both are class one heirs.
according to your.
That under
service-
this circumstance, my lord, the corporation is unable to take a decision.
See, according to that service rules, who is entitled for retirement benefit? Wife. She is the nominee. What is the right of the daughter?
But she is not the nominee.
Then who is the
The
nominee?
first wife, Nagaratna was the nominee.
If Nagratna is dead, then who will be that nominee? Under
Lord,
the rules.
as in view of the compromise, my lord, between
Second wife
the
should be.
petitioner and the fourth respondent, the petitioner has taken the service benefits and the fourth respondent has given the appointment on
And
compassionate
now
ground.
they both are shared that benefit. Now that sharing this amount also, why she is making an objection?
That is the objection given
Yes,
to the corporation.
you survey copy through your office.
Well, if she is working in the
Manoj,
very
she is
same
working, I
corporation,
have produced it,
I can do
Manoj.
it.
Adeshana ಇದೆ, or the compassionate appointment, Adeshana I have produced.
No, you serve that, yes.
Page number 28, Manoj.
Charlie. Serial number ಎಷ್ಟಿದೆ?
Serial 55.
Respondent number 4 is served unrepresented. Learned counsel for the petitioner submitted that. Respondent number 4 is working in third respondent corporation.
Yes.
The third respondent is directed to serve the notice to respondent, serve notice to respondent number 4 through third respondent.
Manoj,
Yes.
date may be fixed, Manoj.
Is this matter?
My lord, copy of the petition, notice may kindly be given to me so that.
Office will give that notice. ಕೊಡ್ತಾರಲ್ಲ ಅವ್ರು? Yes, office will give that notice. Yes. Is this matter on 11th?
Grateful, Manoj.
Yes.
11-2, my lord.
11.
11 to.
Serial number 56 adjourned. Serial number 57, AK Vasant for petitioner, connected matter, Narayana Bhattyam.
Yes.
Appear for the petitioner panel.
Yes.
Serial number 57.
For R11, my lord.
Is a case, but ಇದು ಒಂದು 2 ತಿಂಗಳಿಂದ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ 3 ತಿಂಗಳಿಂದ
Yes.
ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಅನ್ಕೊಂಡೆ trying to bide their time.
We have filed our objections.
Yes.
The point is, this is a case where the respondent, private respondent is appointed as vice chancellor of the VTU University. Respondent number 4 University.
Yes. Who R4?
R4.
Yes.
No, 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 this is a appointment second time.
Yes.
The legality of this was questioned earlier, first time,
Yes.
because that is what my learned friends are relying on.
Yes.
When it was questioned the first time, the legality,
Yes.
this honorable court wide order, Indian order, writ petition order. Yes, but writ petition order said that
Where is that order?
looked into the bona fides of the petitioner thereunder. There was one more petitioner, raised doubts with respect to the petitioner and said that it will not interfere with the appointment because
Where is that order?
that order I'll just.
So not enclosed.
Now, my lord, what has happened? But the courts commented and said, division bench commented and said, in no manner are we expressing anything on the merits of the appointment. So it was left open. Now, my lord, after this, what happened? Kindly come to page number, seal number. It Barthin, I'll just, kindly come to page number. Yes, yes, kindly come to annexure E, page 30.
Yes.
Before that, not annexure A, impugned order.
Yes.
Whereas Dr. Vidyashankar was appointed as vice chancellor. Shall I read?
Yes.
Vishweshwaraya Technological University, Belagavi, under section 13 to the VTU Act for a period of 3 years from the date of assuming charge,
Yes.
with effect from 30/9/22, which will end on 29/9/25.
Yes.
Whereas as per his request and having perused his accomplishment as a Vice Chancellor of Vishweshwaraya Technological University, Belgavi, and his ideas of further goals to be achieved merits for an extension.
Yes.
Now therefore I so and so, Governor of Karnataka, Chancellor of VTU, Belgavi, using my discretion and exercise the powers conferred on me by Section 13 for the VTU Act 1994, hereby extend the term of Dr. Vidya Shankar as the Vice Chancellor.
Hmm.
Now, Lord, this is extended for another term
Yes.
of 3 years.
Yes.
Now, kindly see annexure D.
Yes.
Sorry, brother, annexure D1. Page 31. Now, whereas the tenure, this was in 2022, Lord.
Yes.
So he was continued as a State Open University Vice Chancellor for another 1 year then.
Hmm.
Now kindly come to the University Grants Commission Annexure E. This notification is of the year 2018. Many universities in India are not following this University Grants Commission notification. Therefore, throughout India, right up to the Supreme Court, the appointments of Vice Chancellors are getting quashed because of a certain procedure to be followed under the University Grants Commission.
Yes, what is that?
In the recent law laid down by the Supreme Court, I'll just come to that. Kindly see 7.3, page 33.
Yes.
Vice Chancellor.
Yes.
Now 7.0 may be seen, Lord. Selection of Pro Vice Chancellor / Vice Chancellor of Universities. Now Pro Vice Chancellor, we leave it, Lord. Kindly see 7.3, Vice Chancellor. A person possessing the highest level of competence, integrity, morals, and institutional commitment is to be appointed as Vice Chancellor. But person to be appointed as a Vice Chancellor should be a distinguished academician with a minimum period of 10 years of experience as professor, university, or 10 years of experience in reputed research or academic administrative organization with proof of having demonstrated academic leadership. 2. The selection for the post of Vice Chancellor should be through proper identification by a panel of 3 to 5 persons by a search cum selection committee. Through a public notification or nomination or a talent search process or a combination thereof. The members of such a search cum selection committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. While preparing the panel, the search cum selection committee shall give proper weightage to the academic excellence, exposure to higher education system in the country and abroad, and adequate experience in academic and administrative governance to be given in writing, along with the panel to be submitted to the visitor chancellor. One member of the search cum selection committee shall be nominated by the chairman, University Grants Commission. Kindly see that, Lord. One member of the search committee shall be nominated by the chairman of the UGC for selection of vice chancellors of state, private, and deemed to be universities.
Yes.
The Vice Chancellor shall appoint the Vice Chancellor out of the panel of names recommended by the search cum selection committee. Then, Lord, it goes to the Chancellor after the recommendation. Term of office of Vice Chancellor shall form part and parcel of the service period incumbent making upon him. Now, Lord, kindly come to VTU Technology Act, Annexure F, page 35.
Yes.
In this VTU Technology Act, Section 13 is the Vice Chancellor.
Yes.
The Vice Chancellor shall be a whole-time officer of the university and shall function to be the Chief Academic and Administrative Head. The Vice Chancellor shall be appointed by the Chancellor from a panel of 3 persons who are outstanding in the field of engineering, technology, or education and recommended by the committee referred to in subsection 3 of this section, and such panel shall not contain the name of any member of the subcommittee. For the purpose of subsection 2, the committee shall consist of a member of Academic Senate, a member of Executive Council, the composition of the search committee, member of the Academic Senate.
Now that procedure is entirely different.
Entirely different by the.
But we have not challenged that provision.
No. What has happened is Supreme Court has interpreted that the UGC provisions, the state act provisions must yield to UGC provisions without the challenge.
Now we can consider only if it is challenged.
Illa. Supreme Court has held.
Otherwise,
I'll take
can I say that legislation is wrong without challenging that?
Supreme Court has now interpreted and said that due to the overlapping, the state provision must yield to the state provision, central provision.
Which is that?
Yes, kindly take this judgment. Last time I produced a compilation of judgments. Yes.
Yes, yes, AK Vasant, yes.
This is Gambhidran versus Gadvi. This is the first judgment.
Yes.
2022 5
Yes.
SCC. Now, Lord, in this judgment, kindly see, Lord, internal page. Nannu copy itala.
22 to
ಇಲ್ಲ,
5
ಇದೆ ನಂದು.
SCC.
Gambhidran Gadvi. But the question is formulated 2.1. Shall I read? Shall I read, Lord?
Yes.
2.1. Internal page 10. The UGC regulations 2000.
2.1.
Yes.
Yes.
The UGC regulations 2010 has been substituted subsequently by UGC regulations 2018 with slight modifications,
Yes.
which shall be referred to herein below. Now, Lord, kindly come to 2.4.
Yes.
According to the petitioner, State of Gujarat passed a resolution dated 11/11/2009 adopting the scheme. Since the scheme has been adopted, all regulations framed with UGC are binding upon State of Gujarat, including the respondent SP University. That on adoption of the scheme by the state government as well as SP University, the said university is receiving central financial assistance under the scheme and is included in the list of state of universities receiving central financial assistance as per section 12B of the UGC Act 1956. It is a case on behalf of the petitioner, since scheme has been adopted, all regulations framed by UGC are binding upon state of Gujarat, including the SP University.
Here the state is adopted that.
Yes, now Lord, I'll take your lordships to a further next judgment,
Yes.
where irrespective of adoption of the scheme, it has been made applicable by the
Yes.
Supreme Court. Now Lord, you'll adopt madidare, that's the fact.
Yes.
Now Lord, kindly come to page 2 paragraph 3.
Page
2.6, Lord, where the facts apply.
2.6.
It is a case on behalf of the petitioner that ignoring 7.3.0 of the UGC regulations, a search committee was constituted under section 10(2)B of the Sardar Patel University Act, like 13, Lord, in this. Hereinafter referred to as SPU Act on 29/7/16, with no nominee of the chairman of the UGC. According to the petitioner, even as per section 10(2)B, such committee has only the authority to recommend a panel of suitable candidates.
Yes.
Such committee in the present case exceeded its jurisdiction and prescribed its own eligibility criteria for post of vice chancellor by diluting the eligibility criteria laid down in UGC regulations 2010.
Yes.
Then Lord, kindly come to 3.
Yes.
The petitioner challenged the said appointment of respondent before High Court by way of filing special civil application.
Then
Yes.
here in Gujarat, the state has adopted the UGC
Lord,
scheme.
I'll take your lordships. Just kindly bear with me.
Yes.
Lord. To that pointed question, M.R. Shah, one of the judges who wrote this judgment, subsequently 2 other judgments came up where he said irrespective of adoption.
Yes, we will come to that.
I'll come to that.
Yes, because this facts of the case is not applicable
Yes,
to
yes,
that.
yes. Now, Lord, kindly come to this. I'll just take the enunciation of law here
Yes, yes.
in this judgment and then take your lordships to the next. Now, Lord, kindly come to the questions formulated.
Yes.
Yes, 20. Can you see 20? Question 20 that is formulated. Para 20.
Yes.
Now, the next question which is posed for consideration of this court is whether the appointment of respondent before as vice chancellor to the SP University, Sardar Patel University, respondent number 2 herein can be made said to be contrary to any statutory provisions, and whether can it be said that respondent number 4 fulfills the eligibility criteria for the post of vice chancellor. While examining the aforesaid issues, the relevant provisions of UGC regulations 2010 enacted in the exercise of powers conferred under clauses E and G of subsection 1 of section 26 of the UGC Act and relevant provisions of SPU Act are required to be referred to. Not all of these are referred to.
Yes.
Kindly come to 26.
Yes.
25. Regulation 7.4.0
Yes.
mandates. Now, Lord, the same provision.
Yes.
Kindly see 24, Lord, for a moment.
Yes.
24 refers to the same 7.3 which I read out.
Yes.
And there's a 7.32 selection of vice chancellor
Yes.
should be through proper identification of panel of 3 to 5 names. Next page. Same thing is enunciated in blood. I need not read it.
Yes.
Except that one of the appointees must be by the chairman of the UGC and the remaining must be unattached to the university.
Yes.
25. Regulation 7.4.0 mandates that the university state government shall modify or amend the relevant acts or statutes of the universities concerned within 6 months of adoption of these regulations. Thus, UGC regulations 2010 inter alia prescribed in regulation 7.3.0 the person shall have 10 years of teaching experience, work experience as a professor in the university system. It also provides for constitution of a search committee consisting of a nominee of the visitor chancellor, a nominee of the chairman of the UGC, a nominee of the syndicate executive council of the university, and such committee has to recommend the names of successful candidates. Prior to enactment of the UGC regulations, Union Ministry of Human Resource Development laid down a scheme of revision of pay of 6 teachers. Not all that can be avoided.
Yes.
Kindly come along now 29.
Yes.
Kindly come to 30.
Yes.
Respondent number 4 herein has been appointed as a vice chancellor of the SP University under the SPU Act 1955.
Yes.
Section 10 of the said act relates to the post.
Yes.
Same thing is. Now 32. As per section 10 of the SPU Act does not provide any qualification whatsoever for appointment to the post of vice chancellor. There are no guidelines whatsoever on the eligibility criteria to prescribe by the search committee.
Yes.
On the other hand, UGC regulations 2010-2018 specifically prescribes the qualification eligibility criteria post of vice chancellor. It also provides for the constitution of such committee.
Yes.
As observed here in above, as per regulation 7.3, a person shall have 10 years of teaching experience as a professor in the university. But all that can be again,
Yes.
it's enunciation of the same. Thus the 34. Thus the provisions of SPU Act 1955 provisions under state legislation are just contrary to UGC regulations 2010-2018, which as observed herein are binding on the state government and the universities thereunder. Even the state government has not bothered to amend the legislation to put it on a par with UGC regulations and has continued the appointment in the universities diverse the UGC regulations. 34 at the conclusion.
Yes.
Now, my lord, at this stage it is required to be noted that in the present case, the UGC-wide communication dated 11/8/14 addressed to His Excellency the Governor of Gujarat, who is also the Chancellor of the University, has drawn the attention of His Excellency Governor of Gujarat to ensure that all appointments of Vice Chancellors in the state are made in accordance with the provisions laid down in the UGC regulations. But similar letter would have been written to the Governor of Karnataka. Letter or communication dated. So they invite the attention to 7.3.0. Then it says, kindly see, blood, after that paragraph 7.3.0, it hardly needs any mention that notifications published in the Gazette are mandatory, where they will therefore request Your Excellency to use your good offices to ensure all the appointments of Vice Chancellors in your state are made in accordance with the provisions laid down in the aforementioned regulations of the UGC. I am certain that in your guidance and support in this regard will make a huge difference. So therefore, thereafter, blood, kindly see 39. Despite the above clear instructions from the office of His Excellency, the Governor of Gujarat, who is also the Chancellor of all universities, it is unfortunate that till date the state legislation has not been amended by the state government, and all the appointments to the post of Vice Chancellors in the universities in the said state are being made just contrary to UGC guidelines and regulations. At this stage, it is required to be noted that even in earlier round of litigation being SCS so and so, in which this very petitioner challenged the appointment of this very respondent number 4 as a Vice Chancellor of SPU made in year 2016, the division bench of the High Court made certain observations against the government not adopting the UGC regulations and not amending the state legislation appropriately. 40 relevant observations made by the High Court in para 35 are as under Gambhidran. So therefore, they warn.
Yes.
Kindly see the last placitum G.
Yes.
Pursuant thereto, the Principal Secretary to His Excellency the Governor of Gujarat addressed a communication that 38/14 to the Principal Secretary Government of Gujarat, requesting him to note that said important communication and take necessary steps at the government level. However, it appears that such communication has been ignored and no steps have been taken pursuant thereto. It is therefore high time that State of Gujarat adopts the UGC regulations and amends the state legislation appropriately so that no room is left for any manipulation, arbitrary, nepotism, and favoritism. Thus, now I'm not 41. Thus, despite the communication by the UGC dated 11/8/14, and thereafter the communication by His Excellency the Governor of Gujarat dated 38/14, and even the observations made by the division bench of the High Court in SCC Online Gujarat 35 in its judgment and order at 57/14, In Gambhidran Kanubhai Gadavi versus State of Gujarat, produced here in Wow. It is unfortunate that even as on today, no further steps have been taken by the state government to amend the state legislation and put the same on a par with UGC regulations. And the state and the universities thereunder have continued to make appointments of vice chancellor, just contrary to UGC regulations, which as observed here in above are binding. Now, Lord, after all this, kindly come to 44. Thus, we find that the appointment of respondent number 4 is contrary to UGC regulations 2018. Also, respondent number 4 has been appointed by search committee not constituted as per the UGC, which is the gist of this present case. A search committee was constituted by the vice chancellor originally in 2022. So, same situation. Moreover, respondent number 4 does not fulfill the eligibility criteria as per the UGC regulations 2018, namely having 10 years of teaching work experience as a professor in the university system. As observed here, by adopting the scheme and having accepted 80% of the maintenance expenditure from so and so, which is prescribed as per scheme of 2008, state and universities thereunder are bound by the UGC regulation 2008, including UGC regulation 2018. Now, my lord, then the court goes into 48.
Yes.
It is clear that the observer respondent state of Gujarat has failed to take note of the communication from UGC, and instead the respondent university has left it to the sweet will of the search committee to prescribe the eligibility criteria for appointment of the vice chancellor to the university. Eligibility criteria, when once fixed by UGC and its regulations, would in our view apply to all universities which are aided by the UGC to be bound by the said regulations, even in the absence of the same being incorporated under respective Universities Act of the states. Therefore, when appointment of respondent number 4 is found to be contrary to UGC regulations 2018 and the UGC regulations are having statutory force, we are of the opinion that this is a fit case to issue a writ of quo warranto and to quash and set aside the appointment of respondent number 4 as vice chancellor of the SP University.
Yes.
It cannot be disputed. 50 is not relevant.
Yes.
That UGC regulations are enacted. This is the enunciation of the law.
Yes.
By the UGC in exercise of powers conferred under 26(1)(e) and 26(1)(g) of the UGC Act 1956. Even as per UGC Act, every rule and regulation made under the said Act shall be laid before each House of Parliament. Therefore, being a subordinate legislation, UGC regulations become part of the Act. In case of any conflict between the state legislation and central legislation shall prevail by applying the rule or principle of repugnancy as enunciated in Article 254 of the Constitution, as the subject education is in the concurrent list 3 of the 7th schedule of the Constitution. Therefore, any appointment as a vice chancellor, contrary to the provisions of UGC regulations, can be said to be in violation of statutory provisions warranting a writ of quo warranto.
Yes.
Now, Lord, there afterwards, court refers to various the evolution of the law, and then para 56. Thus,
yes,
universities are autonomous and vice chancellor is the leader of a higher education institution. As per norm, he or she should be an eminent academician, excellent administrator, and also someone who has high moral stature. The aforesaid reports of the Radhakrishnan Commission, Kothari Commission, Gnanam Commission, and Ramlal Parikh Committee have highlighted the importance of the role of vice chancellor in maintaining quality and relevance of universities, in addition to its growth and development, keeping in view the much needed changes from time to time. Further, these committees have also made suggestions and recommendations for identifying the right person for the said position. At this stage, it is correct to say that vice chancellor is the kingpin of a university system and a keeper of the university's conscience. Further, in our view, the search or selection committee plays a vital or significant role in the selection of vice chancellor. Yet the selected vice chancellor's performance in the universities vary from university to university. Therefore, the members of the search committee, who are given the privilege and honor of selecting and suggesting names for the appointment of vice chancellor, are directly or indirectly responsible for the achievement of the university. Commitment to the quality and objectives of the university in particular and higher education system in general are of course deciding factors in selecting the right person. We are sure and hope and trust that while making a fresh appointment of vice chancellor in the state and the universities, then the aforesaid aspect shall be kept in mind by the states and universities. Kindly see that not by the state and university concerned. With this hope and trust, we leave the matter there. After this judgment, 2023 judgment came up. Kindly see the next judgment.
Yes.
Here, the question is formulated at para 2.
Yes.
The appellant here in original writ petitioner, page 34.
Yes.
Preferred the writ petition before the learned single judge of the High Court for writ of quo warranto to declare the appointment of respondent number 1 as Vice Chancellor to the APJ Abdul Kalam University, Thiruvananthapuram as void, ab initio, inter alia, on the grounds that the appointment of respondent 1 derogates the provisions of UGC regulations, that the composition of search committee was not in accordance with UGC regulations 2010. Even the recommendation and appointment of respondent 1 as Vice Chancellor was not in accordance with UGC guidelines. Search committee was required to recommend a panel of 3 to 5 names as to the Chancellor. However, in the present case, only one name was recommended to Chancellor, which was contrary to the UGC regulations. Provisions of the University Act, to the extent it conflicts with UGC regulations, shall not be binding, and the provisions of UGC regulations shall prevail over said legislation to the extent they are in conflict with UGC. The writ was opposed on behalf of the respondent. It was internally contended that unless UGC regulations are adopted, can you see that plot? The University Act enacted by the state shall prevail, and that UGC regulations 2010 are directory for the universities and colleges for the other higher educational institutions and the provisions of the Act, state legislature, as the matter has been left to the state government to adopt and implement. So that question of adoption came up here.
Yes.
Then a single judge dismissed the writ petition relying upon the decision in Kalyani Mathivanan versus KV Jairaj, observing that unless UGC regulations are specifically adopted by the state government, state legislation shall prevail. Therefore, the learned single judge appointed that once the search committee was constituted as per section 13 of the University Act enacted by the state, the appointment of respondent 1 therefore can be said to be a duly constituted search committee, and such the appointment cannot be said to be illegal. Feeling aggrieved and dissatisfied with judgment and order passed by the learned single judge, the appellant preferred the appeal before the division bench. Before the division bench, it was specifically argued and pointed out that in fact the UGC regulations were adopted by the state government. However, the division bench, while dismissing the appeal, has observed that as the amendment to the UGC regulations has not been adopted, the same shall not be applicable or binding while appointing respondent number 1. Again, relying upon the decision of this court in Kalyani Mathivanan, the division bench has dismissed the appeal, which has given rise to the present. Shri Amit George learned senior appearance by the appellant has vehemently submitted that impugned judgments and orders passed by the High Court are contrary to decisions of this court in Gambhidran, the previous one, lot,
Yes.
as well as the recent decision in this court in state of West Bengal was Anindya Sundar Das. It is mainly them that all those contentions can be left aside. 18, para 18.
Yes.
The short question which is posed for consideration of this court is whether while making the appointment of respondent number 1 as Vice Chancellor of the APJ Abdul Kalam Technological University, Thiruvananthapuram, the appointment should be as per prevailing UGC regulations or in effect of the provisions of the University Act 2015, the State Act. The other question which is posed before this court for consideration is whether such committee constituted to recommend the name of respondent number Vice Chancellor of the University can be sued duly constituted search committee. Identical question came to be considered by this court in Gambhidran K. Gadvi versus Kalyani Mathivanan. Now, the issue whether UGC regulations shall prevail versus state legislation or state act, identical question came to be considered by this court in the recent decision of this court in Gambhidran versus Gambhidran K. Gadvi. Well, considering the appointment of the Vice Chancellor to Sardar Patel University, Gujarat, it is specifically observed and held by this court the appointment of Chancellor Vice Chancellor cannot be made divorce the applicable UGC regulations, even if the state act concerned prescribed a diluted eligibility criteria vis-a-vis the criteria prescribed in the applicable UGC regulations. It is further observed that and held by this court in the aforesaid decision that the state act, if not on par with the UGC regulations, must be amended to bring it on par with the applicable UGC regulations, and until then, it is the applicable UGC regulations that shall prevail. It is further observed and held that being a subordinate legislation, UGC regulations become part of the Act. It is further observed and held that in case of any conflict between state legislation and central legislation that is applicable UGC regulations shall prevail by applying the principle of repugnancy under Article 254 of the Constitution, as the subject education is contained in concurrent list of Schedule 7 of the Constitution. The observations made in the relevant parts are as under. Not all that can be.
Yes.
Now, Lord, kindly come to 24. The decision in Gambhidran, yes. The decision in Gambhidran K. Gadvi has been subsequently followed by this court in the recent decision of this court in Anindya Sundar Das. While considering the appointment of Vice Chancellor at Calcutta University, in the said decision, it is also observed that held in para 56 that in view of the decision in Gambhidran K. Gadvi, even if the provisions of the State Act allowed the appointment of the Vice Chancellor by the state government, it would have to be as per the UGC regulations. And any appointment of Vice Chancellor in violation of UGC regulations shall be void ab initio. It is further observed that UGC regulations shall become part of the statute framed by the Parliament and therefore shall prevail. In view of the above two binding decisions of this court, any appointment as a Vice Chancellor made on the recommendation of such committee, which is constituted contrary to the provisions of the UGC regulation, shall be void ab initio. If there is any conflict between the state legislation and union legislation, the union law shall prevail as per Article 254 of the Constitution of India to the extent the provision of the state legislation is repugnant. Therefore, the submission on behalf of the state that unless UGC regulations, kindly see this, Therefore, the submission on behalf of the state that unless UGC regulations are specifically adopted by the state, the UGC regulation shall not be applicable and that the state legislation shall prevail unless the UGC regulations are specifically adopted by the state cannot be accepted, because not by passage of law itself, central statute will override the state statute. Therefore, question of again submitting to adoption doesn't arise. Even otherwise, it is required to be noted in the present case as such a wide order dated 10/10/2010. UGC regulations have been adopted by the state government. At this stage, it is required to be noted that in the order dated 27/3/10, while accepting UGC regulations, specifically observed in para 5 that all universities shall incorporate the UGC regulations in their statutes and regulations within 1 month from the date of the said order, and the government will initiate steps to amend the acts of the universities if required to implement the regulations. It is further mentioned in para 5 the government will also take necessary steps to amend the special rules to give effect. Number 27. Now, the question which is posed for consideration of this court is whether in fact, in the present case, such committee constituted to recommend the name of respondent number 1 Vice Chancellor as Vice Chancellor of the APJ Kalam University, Thiruvananthapuram, can be said to be a duly constituted such committee is concerned. The relevant clause of the UGC Regulations 2019 and Section 13 of the ABJ Abdul Kalam University, Technological University, relating to the appointment of Vice Chancellor are required to be referred to, which are as hereunder. Therefore, not 7.3 is referred to, and then the 13 of the Vice Chancellor.
Yes.
Then the court comes to the conclusion. Right. 28.
Yes.
Thus, as per UGC Regulations 2013, Clause 7.3.0, selection of the Vice Chancellor should be through proper identification of a panel of 3 to 5 names by a search committee, and the members of the search committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the universities concerned or its colleges. It further provides that visitor or chancellor shall appoint the Vice Chancellor out of the names recommended by the search committee. Therefore, the recommendation for appointment as Vice Chancellor should be sent by the search committee, duly constituted, and the search committee has to recommend the names, and thereafter the visitor chancellor shall appoint the Vice Chancellor out of the panel of names recommended by the search committee. While preparing the panel, search committee must give proper weightage to the academic excellence. Then block 29 can be left aside. Finally, the court came to the conclusion at para 31.
Yes.
At this stage, 31.
Yes.
It is required to be noted that even as per Section 13(4) of the Universities Act 2015, the said Section 13 is in parameteria with our Section 13. The committee shall recommend unanimously a panel of not less than 3 suitable names from amongst the eminent persons in the field of engineering sciences, which shall be placed before the visitor chancellor. In the present case, admittedly, the only name of respondent one was recommended to chancellor as per the UGC regulations also. The visitor or chancellor shall appoint the vice chancellor out of the panel of names recommended by the search committee. Therefore, where only one name was recommended and the panel of names was not recommended, chancellor has no option to consider the names of the other candidates. Therefore, the appointment of respondent one can be said to be divorce or contrary to the provisions of UGC regulations as well as of the University Act 2000. Therefore, the appointment of respondent one on the basis of recommendations made by the search committee, which was not a duly constituted search committee as per regulations, UGC regulations, and only one name was recommended in spite of panel of suitable names, 3 to 5 names of persons as required in Section 13(4) of the University Act, the appointment of respondent one can be said to be illegal and void of an issue, and therefore writ of quo warranto is required to be issued. Therefore, court set aside the appointment.
Yes.
The writ petition is allowed, not placitum G above.
Yes.
The writ petition, there shall be a writ of quo warranto declaring the appointment of respondent one as Vice Chancellor of APJ Kalam Technological University as void ab initio, and consequently appointment of respondent one as Vice Chancellor to the said university is quashed and set aside. Now, thereafterwards, 2022, other decision is on the same lines.
Yes.
Narendra Singh Bhandari.
Yes.
We need not refer to this again, where the conflict was considered. Now, kindly see the recent order of Andhra Pradesh High Court following these 3 judgments. Now, Andhra Pradesh High Court was in a exactly parameteria situation as our situation,
Yes.
where the Vice Chancellor was appointed by a search committee not constituted under UGC regulation, and then given an extension without reference to the committee. Now, what happened? Initial appointment was in violation of UGC Act under the Local University Act. Then term got over. After the term got over, he was reappointed. The reappointment was challenged based on the fact that original selection committee selection was void ab initio because it was not constituted under. So exact parameteria, same situation. Kindly see, just page 80.
Yes.
Since common questions of law and facts are involved in these writ petitions, same are taken up together for disposal by way of common judgment and order. Petitioners in this dispute challenge GO so and so dated 28/6/23 issued by government whereby private respondent number 6, Dr. Janakiram Toleti, was reappointed as Vice Chancellor of the Dr. YSR Horticulture University and seek issuance of a writ of quo warranto challenge process. 2, the reappointment was unsustainable in as much as even the initial appointment did not have a nominee of the chairman of the University Grants Commission as required in Regulation 7.2 of the UGC. A chairman nominee was not there. On that sole ground, they changed. At this stage, it is necessary to give the brief material facts in the backdrop and in the backdrop in which the controversy has arisen. GO dated 21/3/18 came to be issued by the government in powers exercise constituting a search committee consisting of chief secretary, so and so, so and so. Lord, that can be, all that can be left aside. Kindly see, Lord,
Yes.
para 6.
Yes.
Para 5, Lord. Subsequently, it appears from the record the government issued another government order reconstituting the search committee, yet again consisting of Chief Secretary, P. Raghav Reddy, ex-Vice Chancellor, Director General, Indian Council of Agricultural Research. Another notification dated 28/11/2019 subsequently came to be issued, inviting applications yet again for the post of Vice Chancellor of said university, with the rider those persons who had earlier applied pursuant to the notification dated 5/8/18 need not apply. Again, based upon the recommendation of such committee, so constituted, respondent number 3 came to be appointed as Vice Chancellor, respondent number 6, to the YSR Horticulture University for a period of 3 years from date of assumption of charge, which was to expire on 29/6/23. Respondent number 6 appears to have addressed a communication dated 16/5/23 to the special horticulture. Not all that can be left aside. Yes. Then again, kindly come not to page 83 above para 11.
Yes.
The reappointment ordered by the government wide GOMS 28/6/23. Yes. Then Lord, they reappointed him. In favor of respondent number 6 appears to be ordered in terms of the aforementioned provisions of the Act and statutes.
Yes.
12 says term of Vice Chancellor appointed in the manner laid down in subsection 1 and 2 of section 26 of the Act will be eligible for reappointment for another term of 3 years. So they said no fresh recruitment process necessary. Yes. They appointed. Now not kindly see the points that are considered. Para 15. Court compares the earlier legislation with the new legislation. In the background of the aforementioned factual and legal position, the petitioners based their challenge on two grounds. Firstly, that respondent number 6 could not have been reappointed without going through selection process yet again in terms of UGC regulations. And secondly, that assuming for any reason that reappointment could be done without subjecting the existing Vice Chancellor to a fresh process of selection. Since the earlier selection of respondent number 6 was in gross violation of UGC regulations, which envisaged the presence of a nominee of the chairman of the University Grants Commission in the search committee, such a selection being based upon recommendations of a selection committee constituted in violation of UGC statutes would be unsustainable in law. Yes. Learned counsel for the petitioners placed reliance on the above judgments. Now, not kindly see 18. Heard counsel for parties. Two issues arise for our consideration in the present case. Whether the reappointment of respondent number 6 as Vice Chancellor is unsustainable in as much as it was made without subjecting said respondent to a regular selection process. 2. Assuming that the reappointment was possible without subjecting the respondent number 6 to a fresh selection process, whether the reappointment becomes unsustainable in as much as the initial selection of respondent number 6 as Vice Chancellor was contrary to the UGC regulations, as the search cum selection committee did not include a nominee of the chairman of the UGC. On the first issue, it is no longer res integra that when it comes to reappointing a Vice Chancellor in terms of the Act or the statutes, it would not be necessary to subject him to a process of selection to a fresh process of selection unless it is so specifically provided.
My friend would be kind enough to give us copies notes. We made 3 or 4 requests.
I'm sorry.
Given
my previously. Kotbudi, ide Kotbudi.
No.
What
changed lawyers? I am telling for the first time. On these things, we should not.
No, even lawyers change, file will not change. File will be transferred to the change in file.
But I have given it to my learner.
I'm grateful.
Yes. No, we will have it some other day.
I understand. It's almost 5:30.
Idondu complete ಮಾಡ್ಬಿಡ್ತೀನಿ.
Yes, yes.
So that then I could summarize next.
Yes. ನನ್ನ friend confidential markings ಇದೆ.
And without marking
ತಗೋಬಹುದಾ?
ತಗೊಳ್ಳಿ.
It is easy for you to reference what you.
ಅಲ್ಲ ಅದು ಇರೋದೇ ಮಾರ್ಕ್ ಮಾಡಿರೋದು ಇನ್ನೇನು ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್ ಇಲ್ಲ. So, Lord, now,
Is there any marking that this para should not be read before the judge?
I look closely for that.
correct. So then, so on this, the court comes to the conclusion.
Yes.
Kindly see, Lord, page 88,
Yes.
62.
Yes.
Where the appointment is to be made for the first time, or where the same person is being appointed as a vice chancellor for the second time, but not in continuation of the first term, procedure provided in section 10 must be gone through. However, in case of reappointment, immediately upon the tenure of the first term coming to an end, there is no requirement to initiate entire process of appointment as provided in section 10 of the Act of 1996. So therefore, the court comes to the conclusion. Now, Lord, kindly see 20.
Yes.
Following the ratio spelt out in aforementioned judgments, we have no hesitation in holding that in the absence of any specific provision in the statutes framed by the government prescribing the need to subject the incumbent vice chancellor to fresh selection process, it would not be necessary for the government to follow that procedure for purpose of reappointment.
Yes.
We may, however, point out that in present case there is no specific provision envisaging reappointment in the parent act, in contradistinction to the provisions of reappointment which were contained in the University Act, which were subject matter of consideration before the apex court discussed here and above. However, in the absence of a specific challenge to the vice of statute, we have no hesitation holding the vice chancellor could have been reappointed without subjecting him to a fresh selection process. Second issue, please, Lord, that falls for our consideration is whether the earlier appointment of respondent number 6, being not in consonance with the UGC regulations, renders his appointment unsustainable. In this case, it is not denied that there was no nominee of the chairman of the University Grants Commission in the search committee, which was otherwise a requirement as per section 7(3) of the UGC regulations to 2018. The argument that the UGC regulations were not mandatory and that the selection process could have been carried out by following provisions of 26(1) of the Horticulture University Act 2007 without the presence of the nominee of the chairman of the UGC as required in the UGC regulations of 2018 is clearly untenable. It is settled that under the UGC Act, every rule and regulation made under the Act shall be laid before each House of Parliament, and therefore being a subordinate UGC legislation, UGC regulation becomes part of the Act. In case of any conflict between state legislation, central legislation shall prevail by applying the principle of repugnancy as enunciated in Article 254 of the Constitution, as the subject education is in concurrent list of the 7th schedule of the Constitution. Reference in this regard can be made to Gambhidran K. Gadvi. Testing the facts of the present case on the touchstone of the law discussed here and above, it thus becomes clear that in the absence of a nominee of the chairman of the University Grants Commission in the Search Cum Selection Committee, recommendations made by a committee would be wide ab initio, as has been held by the apex court in Professor Srijit PS in para number 24. In view of the two binding decisions of this court, any appointment as a vice chancellor made on the recommendation of the search committee, which is constituted contrary to the provisions of UGC regulations, shall be wide ab initio. If that be so, the appointment takes place on the basis of the recommendation of such committee, which is constituted contrary to the provisions of UGC regulations, notwithstanding the fact that initial period of appointment has come to an end, followed by the reappointment of the vice chancellor for a second term, yet the reappointment on that basis cannot be upheld and would therefore become unsustainable. Kindly see that, the chain effect. Be that as it may be, all that the initial appointment and consequently subsequent appointment of private respondent number 6 being contrary to the UGC regulations are bad in law. Consequently, the writ petitions are allowed. There shall be a writ of quo warranto declaring the appointment of respondent number 6 as vice chancellor to the YSR Horticulture University as wide ammunition. Consequently, reappointment shall stand quashed. No orders to cost. Now, Lord, for a moment, this position of law appears to be settled by a recent, at least from the past 3 years. Yes. Supreme Court has stuck to the line that UGC regulations are predominant. They will prevail. All state statutes are denuded of any power. Now, Lord, kindly come to page Annexure G1.
No,
I'll just summarize my argument in.
No, you are completing today.
Next time, Martin. Just I need to show 2 points to your lordships how it is in violation of the UGC regulation. That's
what now our legislation, state legislation is contrary to that UGC regulation.
UGC one though.
That is, there is no dispute.
Yes.
Only thing is that
whether
it is mandatory.
That is also settled.
It's also said.
That is also settled. Lord, I only thing that I would place before your lordships is next date I will perhaps argue for 5 or 10 minutes. That's all. Yes. Only thing that I would point before to your lordships as your lordships text marshals the facts in this case. The grounds raised in Gambhidran case, Srijit case, and in the Andhra Pradesh case was no absence of a nominee of the UGC chairman. That in the selection committee, which rendered the whole appointment void.
No, if this court comes to the conclusion that UGC regulation is prevails, even then if it is not adopted, Then committee is not
Any
constituted. in
committee
terms-
constituted under the state act would be void.
No, if it is constituted in terms of that UGC, then it is prevail. Otherwise it has. to-
Otherwise, it does not. And therefore, annexure G1 series or that series, where the search committee is constituted by the chancellor of Karnataka, that is governor. It is not constituted by the UGC.
There are also other aspects, no? Of course, when we get our turn, I will.
Yes, yes.
And second ground that is raised here is, the UGC regulation 7.3 says, there shall be no person attached to the university in that committee, which is unlike the other cases.
Yes.
Here, persons who were attached to the university and who were in the academic senate, academic council and senate, they were reinstituted into the search panel, contrary to the UGC. So that's the additional ground that we have in this present.
Yes. When do you want?
But Monday,
Not Monday.
Tuesday.
22nd, my lord, so if convenient to your lordship.
22nd.
But 22nd will be too far because
It's not too far, it's 2 days after my learned friend's request. You know,
20th would be.
Nothing is to be forgot because it's only a question of law.
It's
You
a question
have
of law.
It will be, yes. Yeah, that is there.
22nd, 2:30, because it is partially heard.
2:30, if it is convenient to all, we will have.
as your lordship thinks.
Please.
Yes, 2:30.
Please.
2:30.
Obliged.
Grateful.
Grateful.
My lord, serial number 59, my lord. Any date may be
Now
fixed,
we'll-
my lord.
Now we'll complete the list. Wait, yes.
Serial number 58, Ganapati Bhatt.
Madam Lords, I pray for some time to file counter. I have received the instructions 3 days. Yes, Lords.
Yes.
After
How
10
much?
days, 3 days, Lords.
At the request of counsel for the respondent. Is this matter on 29th?
28th or 30th, Lords. 29th. I have.
30th Friday, second February. Yes.
Public.
Serial number 59, Manju Bairal.
I am for petitioner in this case, my lord.
For the respondents, my lord. My lord's 2 weeks time may be
Yes.
granted, my lord.
The respondent has to
The
file
request of-
objections, my lord.
Yes, at the request of counsel for the respondent, 2 weeks time is granted. to
Date
file
may be
objection.
fixed, my lord. Kindly date may be fixed, my lord.
Yes, 4th February, yes.
Much obliged.
Serial number 60, serial number 61, Hanumanta Paravi.
ಮಂಡೇ ಇಲ್ಲ ಅದರ್ ಸೈಡ್ ದೇ ಆರ್ ರೆಡಿ ಎಲ್ಲಿದ್ದಾರೆ ನೀವೇ ಹೇಳ್ತಾ ಇದೀರಲ್ಲ ಎರಡು ನೀವೇ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಿ ಮಂಡೇ ಇಲ್ಲ ಎಸ್ ಆಯ್ತು 22nd yes
Serial number 62, Janardhan G.
yes 2 weeks none appears 2 weeks
Serial number 63, Venkataramaya D.
2 weeks yes who is, nobody is appearing for respondent backward class development corporation who any standing council our Giri our is not served unrepresented managing director of Karnataka State Backward Class Development Corporation Vasant Nagar yes if they are not appeared what to do when do you want 22nd ಬೇಡ 22nd ಅವ್ರ ಮಧ್ಯಾಹ್ನ ಹಾಕೊಂಡಿದೀವಲ್ಲ then it may not reach we'll have it on 27th yes
Serial number 64, Sharon S. Sharon N. Majage.
I'm a proxy counsel
Yes.
for R4 and R5 minutes.
You are appearing for?
Proxy counsel for R4 and R5 minutes.
yes none appear for the petitioner leave this matter of 3 weeks
Serial number 65, Satish K.
65, my lord, transfer matter. Last occasion it was heard, my lord, an employee of Shimoga Institute of Medical Sciences cannot be transferred to, my lord, Haveri Institute, which is another autonomous.
yeah, why it is transferred why it is urgent
But the last occasion, my learned friend was directed to verify whether they have got the power to transfer from one autonomous institute.
yes yes who is that who has to answer government
Government.
yes madam what is your reason
It was argued for some time, but
yes yes you can be transferred who has passed any transfer order
state government.
then you have to be answered whether you have any such where is he
I have no interim order, my lord, your lordship may have.
I will have it on Tuesday
Tuesday.
yes
But may I request you may
no I will
transfer
reach ಅವ್ರು ಹೇಳಿದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್ ಐ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಮೋರ್ ದೆನ್ 10 minutes to decide mister
Here,
if others I will reach B group yes
ಒಂದಿನ ಆಗ್ಲಿಲ್ಲ ಹಿಂದೆ ಹೋದ್ರೆ ರೀಚ್
Yes, yes. ಅಲ್ಲ ಇವತ್ತು ಅವ್ರು ಇದ್ದಿದ್ರೆ that is the issue. If they say show that they have any power, then you are out of the court. Yes, yes.
66 Shivaraju MK.
My lords, appear for the respondents in this matter, my lords. Short matter, my lords. Just recollect, after a period of 10 years, they have knocked the doors of this honorable court for service weightage. On the last date, my lords had even brought up the writ petition.
All other matters, it has been posted. That you are appearing for whom?
I'm appearing for the Residential Education Society, my lords.
Same
Second
matter,
respondent.
ಇನ್ನೊಬ್ರು appear ಆಗ್ತಿರ್ಲಿಲ್ಲ ಯಾರು?
My lordship.
ಶ್ರೀನಿವಾಸ್ ಸಿ. ಅದೇ ಅದೆಲ್ಲ ಸೇಮ್ ತಾನೆ? ಅದೆಲ್ಲ ಯಾವತ್ತೊಂದ್ ದಿನ ಹಾಕೊಂಡಿದ್ದೀವಲ್ಲ ಯಾವತ್ತದು? ಇವರು ನಾರಾಯಣ ಸ್ವಾಮಿ ಅಪಿಯರ್ ಆದ್ರು ನೋಡಿ. 27.
Please, my
have it on
lords.
27. This also. 27 ನಿಮ್ದು ಯಾವ್ದು? 72 ಅಷ್ಟೇ. 27. Yes.
ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್? 67 ಶರತ್ ಎಸ್ ಗೌಡ.
Yes, leave this matter after 2 weeks.
68 ಸಂಗಮೇಶ್ MN.
For the petitioner, my lord. My lord, there's a selection procedure, my lord. My name has not been forthcoming in the selection list.
Selection
So
of what post?
to the beat forest officer guardman.
Beat forest.
They've already,
Is it civil servant? Forest department?
How this?
Then you have to go to that KT.
My lord, in that they've already issued the final list also, my lord.
Aito, whether you are in a government servant?
No, my lord, I'm not. I've applied for the
Conservation of forest. Apply for which post, mister?
to the post of beat forest officer.
Then you have to go to that KT.
Well, Adralli Swami, on the last hearing date, they have already issued the final list also in the
Aito,
procedure.
ಅದನ್ನು ಕೂಡ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಲ್ಲ. Is it, mister? Will permit you to go to there?
Please, my lord.
With liberty, yes. At outside, government advocate submitted that. Post which petitioner seeking relief is in a civil post. He has to approach Karnataka Service State Administrative Tribunal in view of judgment of apex court so and so. The above writ petition is disposed of, reserving liberty to the petitioner to approach appropriate legal forum.
Please.
Yes.
Pending applications.
All pending applications are disposed.
Number 69 70 Arjan, 70 71 Arjan, final hearing.
Final hearing date.
My lord, one submission. My lord.
Yes.
Serial number 60 and serial number 15, my lord. My lord.
Serial number?
60.
1660.
And serial number 15, connected matters at serial number 15, my lords. My lords were kind enough to list the matter on the 28th. Learned counsel for the respondent was present. One request to the court, my lords, on the from 23rd to 28th, I'm traveling. Any other date convenient to the court, my lords, if it's possible.
No,
I
is
apologize.
on your request it is posted on that day.
Please, my lords, I understand because there was
Order sheet
a.
signed. Order sheet you have signed. You do one thing. You request any of your colleagues to request the date on that day. We'll grant the time.
Can I request for a shorter date on 28th or 29th, subject to the convenience
Yes,
of the
on
court?
that day somebody has to request. We'll consider.
Serial number 81, my lord. This is a matter related to pension, my lord. I moved this matter and your lordship has been listed.
The problem is that earlier bench has given some RSS as date. ಅದ್ರ ಮಧ್ಯದಲ್ಲಿ ಸಿಕ್ಕಾಕ್ಬೋದಿದ್ದಾವೆ. ಇದು ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಇದು ಬಿ ಗ್ರೂಪ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರು ರೀಚ್ ಆಗುತ್ತೆ.
RSA ಡೇಟ್ ಇದ್ರೆ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ರಿಟ್ ಆಮೇಲೆ RSA ಮಾಡ್ತೀವಿ ಬರುತ್ತಲ್ಲ. Whatever may be that year, first ರಿಟ್ ಆಮೇಲೆ ಡೇಟ್ ಗಿವನ್ RSA. ಅವಾಗ ಇಟ್ ವಿಲ್ ಕಮ್.
ಡೇಟ್ ಯಾವ್ದೋ ಒಂದು ಕೊಟ್ಬಿಡಿ. 28th.
27th. Yes.
ಗಿರೀಶ್ ಇದೊಂದು ಬಾಕ್ಷಿಗೆ ಹಾಕ್ಬೇಕು. ಬಾಕ್ಷಿಗೆ ಗಿರೀಶ್ ಪಾಪ ಅಲ್ಲೇನಾರು ಮೇಲೆ ಇಟ್ಟವ್ರು ಇದೊಂದು ಬಾಕ್ಷಿಗಂತೆ ಅವ್ರಿಗೆ ಕೇಳಿ ಯಾವ ಬಾಕ್ಸಿಗೆ ಹಾಕ್ಬೇಕು ಗಿರೀಶ್, ಯಾವ ಬಾಕ್ಸ್? ಚೇಂಬರ್ ಬಾಕ್ಸ್ ಅಲ್ಲ, ನಮ್ ಬಾಕ್ಸ್ ಇರಲ್ವಲ್ಲ, ಕೇಳ್ಕೊಡಿ ಯಾವ ಬಾಕ್ಸ್. ಆಮೇಲೆ ಕನ್ಫ್ಯೂಸ್ ಆಗಿ ಹೋಗ್ತೇವೆ. ಒಂದ್ ನಿಮಿಷ ತಮ್ ಯಾವ ಬಾಕ್ಸ್ ಹೇಳ್ತಾರೋ ಕೇಳ್ಬಿಟ್ಟು ಹಾಕ್ಬೇಕು. ಇದು Final hearing matter, 73, 74 adjourn, 75 adjourn, 76 adjourn, 77 adjourn, 78 adjourn, 79 adjourn. ಅಷ್ಟೇ ಮುಗಿತಲ್ಲ.